Appellate side, Delhi list item number 1. First
Apart from the reasons stated above, DVC is also accountable for breach of the principles of natural justice. DVC as a tendering authority must act within the bounds of fairness and transparency and ensure that the rejection of a bidder conforms to the tender conditions designed by DVC. The impugned rejection of the petitioner does not satisfy this benchmark and is hence arbitrary, unreasonable, and calls for interference. The impugned letters of 15/11/2022 and 24/11/2022 are accordingly quashed. The respondent DVC shall evaluate the technical bid of the petitioner and allow the petitioner to participate in the tender. WPA 26117 and 27405/2022 are disposed of in terms of this judgment.
I formally seek for a stay of the operation of the order.
Learned counsel appearing for DVC. Prays for stay of the operation of this judgment. Prays for stay of this judgment. Stop. Considering the facts and considerations, facts and circumstances of the tender as stated in the judgment, the prayer for stay is considered and refused.
Grateful note.
Two writ petitions I've disposed of.
Well, at both the matters, well, I'll pray for stay.
There's one judgment only.
Well,
Yes.
Item number 3.
Mr. Banerjee, I will dictate the judgment in court at 11:30.
Great.
I don't want to stop the list now. Yes.
Great.
Item number 4.
I'm for the state response.
Yes, I will dictate the judgment at 12:30 in court.
Well, I'll show two things to you, Lordship.
Mr. Chatterjee, no. What do you want to show?
First thing is
Malice in law.
No, that I have shown you, Lordship. Lord. Yesterday it was submitted by my learned friend at page 11, Lord, that there is an alternative land available. We'll show that is for a different sub-center, different health center. And Milord,
This is what Shushasto Kendra.
Yes, Milord.
Yes.
That is for a different Shushasto Kendra. And Milord, I'll want your Lordship to take note of paragraph 7 of this document, Milord, where your Lordship will kindly.
Please give a copy to your learned friend.
Yes. My Lord will kindly remember this sketch map. Milord, this sketch map had, Milord, indicated that 60 will be consumed for the health center and 45, Milord, will be left free. Milord, without compromising on the health center, Milord, I can give away another 10. So, Milord, the health center will be at
55.
55, and Milord, they will
No,
also
free space will be 55.
55, Milord. This, Milord, I could impress upon my client, Milord. It's my duty to point out to the.
So 55, and the blocked portion will be how much?
Milord, blocked portion will be, naturally, Milord, it will be all 50.
50.
50. That, Milord, is stated in this paragraph, last paragraph, Milord. 60 to 40, Milord. 60 will come to 40, Milord.
Very well. 50 will be blocked and 55 will be the free space. I will dictate the judgment at 12:30. And with regard to malice in law, please share the document with Mr. Banerjee.
I have given, Milord.
Very well.
Oh,
Yes.
document.
Yes, call on the next matter.
You mentioned item number 7.
My lord, I am led by Mr. DSGI, who is online.
My lord,
Appear-
I beg to appear on behalf of my lord, the respondent Directorate of Enforcement, my lord.
And for the petitioner, we recall my lord this.
Do you have a sore throat or did you have a hard labor day yesterday? Which one?
No, my lord, tomorrow, my lord, I will be able to join physically because 7 days isolation is prescribed. My lord, may I just say this, my lord, insofar as this particular application is concerned?
I thought this is for settlement. That's why it's to be mentioned.
No, my lord, this was served on us, my lord. Now, my lord, peculiarly, we find, my lord, without leave of your lordship, my lord, yesterday a suggested order, my lord, was handed over to us. My lord, I do not know, my lord, how, my lord, that was possible. My lord, we have sent the suggested order.
What suggested order?
I'll tell my lord. My lord, we'll recall my lord this matter, my lord, with regard to the insurance. There was penalty imposed on us, my lord, for 80 crores with a
No,
fine.
Mr. Mukherjee said it's been settled. So that is why it's in the list.
Yes, my lord, settled, my lord. We have, my lord, we want to, now, my lord, what has happened, my lord, we'll also recall that, my lord, there was a question of, my lord, raising, my lord, capital for, my lord, further continuance of the business. Now, my
Yes.
lord, with this, my lord, order pending, my lord, the enforcement director, quite naturally, my lord, the idea is aware, so, my lord, we could not raise capital. So, in the end, my lord, unfortunately, my lord, we can't, my lord, wait till, my lord, its logical consequence. So, my lord, what we, my lord, decided, and, my lord, but one of the shareholders, my lord, is going to pay 80 crores. But, my lord, we also want, my lord, an observation that, my lord, this is without, my lord, really, my lord, not going into, my lord, on the question of, my lord, because if the finding is still there, then there's a difficulty. And that is why, my lord, we shared an order with them if they have any difficulty with regard to this or not. That's, my lord, the only reason. I don't know what, my lord, my learned friend's instructions are, but we wanted to pay off this 80 crore without, my lord, there being really, my lord,
No, Mr. Bhattacharya, you're not aware of any settlement. What is it?
No, my lord, I asked my learned junior to find out, my lord, yesterday evening, once this was handed over to us.
Mention Mr. Mukherjee upon notice.
what notice I mentioned, my lord.
Yes, yes.
So, my lord, I asked him to find out, my lord, if my instructions are correct, my lord, there are possibly, my lord, no such talks, my lord. But we are in the process of receiving instructions, my lord. These are very, my lord, high stake matters. Now, 80 crores has been imposed as a penalty. Now, suddenly we find, my lord, a suggested order coming in stating that,
Is Chidambaram also in the loop?
Yes, my lord. In fact, my lord, we can't, unfortunately, my lord, we couldn't pursue the matter, my lord, because even if, my lord, whatever happened here, my lord, it would have gone up, my lord, and we can't, my lord, unfortunately wait because the business, my lord, will sink now. We can't raise capital because, my lord, the idea says, sorry, till this is over, we cannot do anything.
no, my lord, the matter was being heard by your lordship, my lord.
Mr. Bhattacharya, you can take one day to consider whatever order is being handed up. I'm also not aware. I will also take a
Well,
copy today. And then you can come back tomorrow.
But
Right.
instead of tomorrow, my lord, may I come back on Thursday?
Whatever, my lord, is convenient, but, my lord, let him, my lord.
It's a penal statute at the end of the day, my lord, because
Where
there is a pen.
1 minute. Where
Well-
is the 8 crores coming in, Mr.
My lord, just
manager?
kindly, first page itself, my lord, one of the promoters, shareholders is agreeable to pay an amount of 80 crores to enforcement directorate. Then, my lord, sees directorate in full and final settlement without accepting the above payment towards penalty for alleged violation. In view of the aforesaid, applications filed by the petitioners are allowed and leave is granted to the petitioners. Application means, my lord, the application which we have filed now.
Yes.
Granted to the petitioners to pay amount of rupees 80 crores to Silica Developers Tribunal full and final settlement. Upon payment by Silica Developers of the aforesaid amount, petitioners response 2 and 3 shall stand discharged of all obligation under the impugned order and all allegation the violation of FEMA rules shall stand closed. Consequently, these petitions are disposed of. Then, my lord, we wanted a clarification
And
that, my lord,
who is this Celica, did you say?
my lord, that's one of the shareholders, my lord, of, my lord, the Indian
Promoter,
shareholders, my
promoter
lord,
shareholders.
of the, my lord, company itself, of the insurance company.
Mr. Bhattacharya, you're getting the money in any case, but
Well, the dichotomy is, my lord, they're admitting the penalty amount, but saying that, no, this should not be constituted as a penalty.
Saying that the finding, my lord, should not be, my lord, otherwise, my lord, we'll have.
it will be like some of the other orders passed by any court, which says that the court hasn't gone into the merits of the case. Something like that.
But I'll come back on Thursday, my lord, with the instructions.
Yes, this matter was mentioned yesterday on behalf of the petitioners, stating that the parties wish to settle the matter. Stop. Draft order has been handed up to the court by learned counsel appearing for the petitioners has handed up a draft copy of an order giving the necessary particulars of the payment to be made by one of the promoter shareholders of the first petitioner to the enforcement directorate. Stop. Next, learned DSG appearing for the enforcement directorate seeks time to consider the order. Stop. This matter on 4th April 2020, 4th May 2023 as prayed for.
My lord, and I also dispute, my lord, the submission that parties have agreed to settle, my lord. So far as the enforcement directorate is concerned, my lord, possibly, my lord, there is no, my lord, may kindly record that.
Poster, sir.
Council submits, last jekhane bolam, the learned DSG submits that there is that this is only a proposal and parties have not taken any active steps to settle the matter.
Great.
Great.
To be mentioned.
Deeply placed. No.
Item number 10,
May it please, my lord.
You are in item number 10.
Yes.
Yes.
Kept for correction.
Correction of order, my lord.
What correction?
My lord, I am not briefed in this matter. Mr. Shatru Banerjee is leading me.
Number? Key number bullet. Yes, learned counsel who mentioned the matter for listing is not present in court. Stop. Counsel appearing for? Who is Mr. Banerjee is appearing for?
For Union of India, my lord.
Learned counsel appearing for the Union of India who mentioned the matter for listing is not present in court. Stop. The number mentioned in the cause title of the order passed on 28/4/2023 is required to be corrected. Stop. The number should be key number chilo
6526, Your Lordship.
6526 of 2023. Stop. Let the correction be made to the order and be incorporated as part thereof. Stop.
Much.
Great.
Much.
item number 11,
My lord, there's a note, my lord, I was supposed to hand over. And my lord, last to last order, my lord, there was an order passed giving me an opportunity to file an affidavit by yesterday. I mentioned the matter, my lord, if it can be extended by a day. Now, my lord,
Mr. Ray, not required. Why do you want to now file an affidavit? You filed a note.
my lord, note is only 2 or 3 page, but my lord, affidavit I want.
So in the note, you refer to whatever documents you want to refer to.
Well, that's the reason why I paid for and was given till yesterday. His reason is, my lord, they are saying, my lord, certain things.
Very well. So have you filed the affidavit or not?
No, I have given a advance copy to them. It's already affirmed. Without the leave, my lord, I cannot.
Have you got a copy, Mr. Shah?
Yes.
12 last night at 12 o'clock, they served us over mail.
Yes, ma'am.
Very well. In any case, you will get a chance of now instead of 2, you will get 3 minutes. So you can respond to Mr. Ray's documents.
All right.
Yes.
May I just? No, so far as the note is concerned, my lord,
Yes.
may I hand over? My lord,
If you think the documents are important, then I will give you less than 2 minutes, Mr. Shah. All right? Yes.
my lord, why he wanted to submit this, my lord, I have handed over a note and come to that note immediately. But the importance of this document is they are saying that in the petition, my lord, they have said that they have always supplied 2 evaluators, always. But
Yes.
from submission of the bar is
that no, I supply evaluators according to the choice of the railways. Railways say one, I am supplying one. Railways says two, I am supplying two.
So now you tell them how many you want. They will
I
supply.
cannot. That's what the issue that what I wanted to say is
Yes.
they are supposed to supply one and one has to configure. And one is to cater up to it. I'm coming in one by one. They say their competitors are also supplying two. I have shown my lord 4 documents to say that one evaluator can configure both proprietary reset and hard reset. This is one. Number two, they have relied upon a Siemens document of 2010. I have shown documents.
Mr. Ray, if you don't want complaints from the adjoining courts, you can remove the microphone. Yes.
Sorry, my lord. So, my lord, so far as the affidavit is concerned, kindly take, my lord, 2 or 3 documents, which I think, my lord, in my humble submission, will make the matter more clear. What we are talking about is, my lord, kindly straight away, my lord, come.
The matter was clear to me till you started your submissions. Yes, that's correct. It was very clear to me till you started.
May I just try to, my lord, assist this honorable court, my lord, in the manner, my lord, because we are talking about, my lord, safety of the passengers, and this is signaling system. If one thing goes down wrong, then, my lord, accident is bound to happen. And that's the reason in the first order, my lord was pleased to observe that considering the safety, a limited order was passed.
First order, I could not understand the matter. That's why I didn't pass an interim order. That's why.
My lord, may I only pray that
Yes.
in order to, my lord, this is a very complicated thing if not shown. My lord, may I just say what is an evaluator? Because my lord has said what is a reset, my lord, is also not clear. Subject to, my lord, correction by my lord. My lord, kindly take 2 pictures because in my humble submission, it may throw some light as to what is happening. Kindly come to page 42 of this affidavit in reply which I have filed. This is, my lord,
Yes.
this is, my lord, a reset box. Kindly see power on, then, my lord, preparatory reset, then line verified. Then, my lord, section clear, then reset, and then, my lord, section occupied. This is the 1 unit. So the question of, my lord, preparatory reset and line verified is hard reset is there in one unit itself. Now what happens is when a train comes in, my lord, the track section automatically gets occupied. Kindly come to, my lord, page 46 once. What happens here? My lord, will find that section clear is there both in and out. There's a green light. Rail comes in, the wheels comes in, it gets occupied. Normally in one train, there are 36 wheels. So it gets occupied and then it should go out and this should be cleared. Why is this preparatory reset, hard reset? What is the difference? Now, my lord, and where we will apply preparatory reset and hard reset? Hard reset and preparatory reset, my lord, are resetting because there is a defect. I am now trying to correct it. Now, there are 2 modes of correction. One is preparatory and one is conditional hard disk. What is the difference, my lord? Difference is in a preparatory method, the train goes very slowly. It's a sort of in my humble submission, my lord, a guinea pig sort of a situation. You are testing. But in a conditional hard reset, the train goes normal in the normal speed. Now, when will the train go, my lord, will depend upon what sort of reset I am setting. Now, where is this evaluator coming? What is it evaluating? Because evaluator, my lord, has to evaluate something. Now, evaluator, my lord, is connected with the DP, detection points. Kindly see page 43, my lord. This is a picture of an evaluator consisting of, my lord, 8 detection points.
Yes.
And second one is, my lord, 1, 2, 3, 4, 5, 6, 7. There are 6 detection points so far as the second one is concerned. And track section, second is, my lord, there are 3 track sections. And in the up, my lord, there are 4 track sections. How do I get it?
this units, my lord, 1, 2, 3, 4, 5, 6, 7, 8 with two red buttons, my lord. These are the detection points. What is detection point, my lord? Kindly see. This is fixed with the railways. My lord, page 45 and 45A. In the rail, there is a detection point which is like this. Kindly see, my lord. When the wheels goes one way or the other, it takes the information. It passes on to the box which is, my lord, at page 45. And from that data goes into the evaluator. Now, why are they saying, you say how many evaluators are required, which they have not pleaded. Their pleading is, I have supplied 2 evaluators at every point of time.
Yes.
Now, when I say that you have supplied 2 evaluators every point of time, but your own document is showing no, you have not, because our contention is it has to be done with 1. So far as 8 detection points are concerned, 16 detection point, 2, it goes on like this as per the deviation taken by them. So they say, my lord, this is in one humble submission from the bar, that no, railway has to decide, my lord, 1 or 2. Depending upon that, I will give it. Now, what will the railway decide? How?
But Mr. Ray, isn't there a, that whatever the technical word was, isn't there a template which the petitioner has to follow? There's some sort of a technical requirement template.
That's what I'm submitting. What are they?
There's a form, there's a procedure.
My subject to correction, my lord. The form I was showing to my lord as per P10, that is the parent document, says 1 evaluator can cater up to 40 detection points. But when they have applied to become a vendor registration, that's why I am emphasizing this point here clearly, because they say I have complied with, no. You have said that you will comply. When you applied for a vendor registration, nobody can supply this. You have to have a registration as a vendor. Then only you can supply the equipment if the equipment are in accordance with the specifications. So first is a vendor registration. Now at the time of vendor registration, they say, I can only supply 1 evaluator which will cater up to 8 detection point and 6 track section. Normally, my lord, in a straight line, kindly see, if there are 8 points, there will be 7 track sections. But they say 8, this is annexure P4 of their document, which says, my lord, 8 detection point and 6 track section.
Mr. Ray, I've told you yesterday, you are free to make your submissions, but I don't want to be confused.
No, I'm not. I am trying to say, my lord, the impression that is given, my lord.
This is in the pleading.
My lord, it is there in the pleading. It is there on their own document. Unless there is an admission of their wrong, well, may I just formulate? Because why I'm saying this? This is on a technical and very specific safety of the Indian Railways, where we are trying to implement something known as coverage today, where the, my lord, high-speed train can automatically stop. Now, this detection points gather tremendous importance here. And that is the reason, my lord, why this, what they are supplying, if it is not in accordance with the parameters of specifications, then in my humble submission, a railway has the right to reject. They have not rejected. They say, you correct, you take corrective steps. Now, when I say corrective steps, they said, no, there is nothing to be corrected. Everything was okay. We join issue there. Everything was not okay.
But then you stopped inspection, so
No,
therefore
no.
they were prejudiced.
No, my lord, I'm not, my lord, why, subject to correction, my lord, I have taken inspection. Admitted position, my lord.
No, after the order of the court, didn't you say that you go back to version 3.0, whatever that requirement was?
No, that requirement was not to go back. My lord, I submit, this is the case of the railways, my lord, that version 3 cannot be diluted at any point of time. And previously also they were following version 3. All the contracts mention version 3.
Very well. Mr. Ray, I
Madam-
don't want to hear any more because I don't want my mind to be unsettled. All right.
No, my lord,
You have stated everything in your note.
no, may I just have to give an,
In 2 minutes, Mr. Ray, 2 minutes.
may I
Because,
only,
no. Everything, Mr. Ray, I have asked you to give a note.
I-
Everything should be in that note.
with 2-3 pages, but kindly consider this, my, if
2 more minutes, Mr. Ray. I will give the same time to Mr. Shah. 2 more
But-
minutes.
Madam, may I just, because well, it requires some attention.
Mr. Ray, no, formulate your points, at best 5 minutes. Formulate your points.
But kindly come to the notes, my lord. Because the petitioner has filed a note, my lord, which no copy was given to us, but be that as it may, my lord, I don't know what they have stated in the note.
No, in matters where I feel like I make an order for exchange, otherwise usually notes are not
Very well, my
exchanged.
lord.
Yes,
My lord, the first point is, my lord, that this supply was to be made as per, my lord, version 3.
yes.
Now this, my lord, will get at annexure P10. Now, my lord, if my lord kindly considers this
Annexure P10 is which page, Mr. Shah?
page 227, page 227 of the writ petition.
Yes,
I'll just give you
yes,
page 227 of the writ petition. Now, my lord, petition to plot for a bar call.
yes.
Now, my lord, if my lord kindly comes, I have given the clauses 5.5.4 and 5.5.8.
Which,
Well-
where do I find these clauses?
My
Give me the page.
170, 169 and 170 of the writ petition.
Yes,
Then, my lord, clause 5.3.7 is at page 169.
why have you not given the page numbers in the note, Mr. Ray? Very well, yes,
I'm very sorry because
that's all right, go on, please.
5.5.3 is one. So what is said there? And my lord, 163 to 172. Why this is important? My lord, if my lord kindly gives us one opportunity to one page only, 163 and 164. They are saying, just my lord, just give me 10 minutes by the watch.
No, 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 no,
Well,
5 minutes.
well,
5 minutes.
163, my lord, please, if possible.
163 of
Of the
what?
writ petition, my lord, of the writ petition. I'm only on the writ petition. They say they are going to cater only 8 track sections and 7, and their own document will show that they have only supplied one evaluator.
Very well.
And
Yes.
my lord, kindly, may I just request, well, page 355.
Mr. Ray, you can place your note or you can place documents, either or, all
Okay.
right, in 5 minutes. Yes.
This is the evaluator. Now, my lord, relying upon that representation that they will supply 8 detection points and 6 track sections in one evaluator, I have given them the registration. I have given them the registration at P5, that is, my lord, page 191 to 195.
I don't know why you mentioned your P's but not pages in the note. I don't have the time to hunt for these documents. Just give me the page number, please. What is P4? Where is it?
My lord, P4.
You have mentioned all these in your notes, but without the page numbers. I have zero time to look for pages now.
I will give you a note with the page number.
No, no, no. Tell me now.
Page 150, page 157 to 190.
P4,
P4.
157.
Yes.
Very well. Yes.
P5 is 191 to 195.
Yes.
And my lord, P16 and 17 is 883 and 884.
P5 is?
P5, 91 to 195.
Very well. Yes.
And 883 to 884.
What 883?
Well, that is my lord, P16 and P17.
Yes.
Here, my lord, kindly remember, Mr. Shah submitted that, no, it is premeditated because signature is on 9th and inspection is on 10th of November. It's the other way around, my lord. Inspection took place by a person who is on the lower rung on 9th. He has prepared a report. The senior person went on 10th and the digital signature of the senior person is on 10th. And on 10th, it is found, my lord, that they are not being complied with. So the promise to comply with version P3 is not there. Now, my lord, in the pleadings, they have said that all times they have supplied 2 evaluators. 2 evaluators to cater, my lord, how much? Kindly, if my lord kindly gives me one opportunity to place only 2 pages, 355 and 357.
Very well. I'm writing it down. 355, 357. Which point is
My lord,
this?
point is, they are saying 2 evaluators.
No, which point in your
Yes,
note
that
this?
is, my lord, paragraph 6.
6.
Yes.
So you have jumped from 3 to 6.
No, my 3 I have submitted. 4, my lord, that the allegations that undisclosed computers are giving 2 evaluators is incorrect, my lord. I have shown, my lord, 4 documents at least to show that one evaluator can configure both preparatory reset and hard reset. This is, my lord, pages 27 to 29th of the reply.
These are new documents, my lord, to confront the new point.
27 to 29 is
Oh.
your paragraph 4.
Paragraph 4 of the reply, my lord, of the
Yes.
reply filed today.
Yes.
Now, my lord,
You mean your opposition?
yes,
Last affidavit.
the last affidavit.
Yes.
Then, my lord, as per the pleadings, my lord, they have said they have supplied 2 evaluators always. This is denied by the respondent. It will appear from the records that the writ will have not supplied 2 evaluators. Why I am saying so? If my lord kindly comes to page 355, my lord will find they have given a list.
This is point 5.
Point, my lord, 6.
6. 355. Very well.
355. Compare that, my lord, with 363.
Yeah.
They have supplied for 500 500 detection points, 102 evaluators. So it is not 2, it is 102. Why? Because they have to cater 8 track section. Now, if they have to cater 8 track section, they have to supply 2, then the figure is coming to 1.
Mr. Ray, I've been telling you from yesterday, you tell them how many evaluators you want, they will arrange for that.
My lord, the evaluators they are arranging, what is the point? Kindly consider, our evaluator, my lord, has been dictated by the Southeastern Railway. We are only RDSO. Kindly consider our limited job is for research and development and to see whether the
So you are the deciding authority. You are the one who was doing all this inspection and everything.
my lord, inspection we are doing as per the contract.
Very well. So you tell them how many evaluators you want.
My lord, I want an evaluator which can cater both preparatory and hard research, which was the contract.
So tell them that. Why have you not told them that?
Well, it has been told it is they were not giving in the last where they have stopped. Now they say I have to conduct the test with the acceptance test format and not by seeing the specifications. That is not possible. I have to see whether your detection points and evaluator are matching the version 3, which is P10. They are
Very well. So you tell them according to version 3.0, how many evaluators are required. Have you told them that?
yes, they were giving. The evaluator comes with the machine. I am not saying because they say they were always supplying 2.
Evaluators comes with the machine. They're robots or what?
Malad, there are detection points
Yes.
which I am inspecting. Coupled with detection points, there are evaluators. Now, for 4 track sections or 8 track sections, here I will show their own documents say 8. They have only given us inspection of 1 evaluator. Now, what they're saying? They are saying for preparatory research 1 evaluator, for hard disk 1 evaluator. This
Very
is
well. That is your point. I've understood your point. That's point 6, paragraph 6.
now, my lord, whether the repetitions have supplied 1 evaluator or 2 evaluators, it's a disputed question of fact because they are saying they have supplied 2.
Very well. Yes. Next.
Then, my lord, what we have said is to take corrective and preventive actions. Why my lord was saying why we have said. I have said, my lord, corrective and preventive actions.
Mr. Ray, your 5 your 5 minutes are over. Now you just choose which point you want to focus on from the note.
My lord,
Yes. No, Mr. Ray, I have to keep my time. Yes.
about the vigilance point, my lord, vigilance letter, I submit, my lord, I have got nothing to do with the vigilance. Why? Because those guidelines of 508 will apply if a vigilance officer is inquiring. Here I have shown, my lord, the person who is today I have got a letter. I have seen that person, checked that person. The person has,
That person is a Supreme Court lawyer.
yes, and he has filed an FIR complaint also. There is no dispute as to that person is making the complaint. And whether a vigilance officer at the time of inquiry, what will do, RDSO has got nothing to do with that. So the argument, my lord, that it has not been done compliance with that vigilance manual, in my humble submission, is immaterial. Whether I check on that or not is today immaterial. I am going with the safety regulation of version 3, and admittedly on version 3, they are failing. This is so far version. Now, so far as these 2 letters are concerned, which they are relying upon as if that we have said 1 or 2 doesn't matter. That is at page 909 and my lord 989. Now, these 2 letters of 15th of November and 15th of December, these 2 letters says what? That 1 evaluator or 2 evaluator, those clauses will not indicate. Those clauses are not indicating. I have to say,
Says whether it is one or two doesn't matter.
doesn't, my lord, 1 or 2 doesn't matter. 1 or 2 or 1 or 500 doesn't matter, but it will relate upon how many track sections or how many DP box. Evaluated, my lord, cannot operate in thin air.
So it's an afterthought on your part.
No,
No.
my lord, why will it be afterthought? For 69 times we have done. What we have done? We have checked whether it is complying the parameters of safety.
Very well. Mr. Ray, what is this interesting point about pseudonyms and anonyms?
Sorry, my lord, the paragraph, I'm sorry. Huh? 16.
I will only look at that point,
Oh.
Mr. Ray.
Sorry,
Point number 16.
yes,
16.
this is vigilance point, my lord. If it is in my humble submission that if the author of the complaint is a particular person, then it is for the vigilance to decide whether he has made the complaint or not. RDS has got nothing to do. He has made a complaint, it's his job, but we are complying with law, which is, my lord, version 3. And for 69 times we have complied with, even from their own documents, it will appear, my lord, that there is only one evaluator they are giving us. And their one evaluator cannot configure both.
Very well. So you have also taken the point of Indian conditions.
Yes, but that
acclimatization.
is there in the my lord, the acceptance test. Kindly make a note, my lord, page 158 and 160. On that point, what are they saying? These are meant for Indian conditions and subject to correction. I don't, my lord has used the expression, my lord, Indian standard, whatever, that will subject to correction, it will be in independent safety assessor. In the order of,
must have been a mistake on my part.
no, not that. We could not assist properly. That's the reason. But these two conditions are there throughout. Indianization and independent surveyor assessment certificate. So by asking them, I have not done anything wrong. And my lord, the most important thing is, they have said they have supplied 2 evaluators. If it is shown from their own documents that they have not supplied 2 evaluators, then, my lord, their assertion goes.
Actually, Mr. Ray, your submissions are far more clear than the note. So it's good that I heard you. You have made the note easier, simpler to understand.
My lord, so far as my lord's query is concerned, that why can't we say whether how many evaluators we want? The answer is this, my lord. I can say how many evaluators we want if the evaluator can configure both preparatory reset and hard reset.
And you have said that the provisions of the European Railway Agency are not applicable
Yes,
in Indian
certainly
conditions. Not
Certainly
conditions.
not.
So whatever they are manufacturing, not acclimatized.
No. They have said about the chain. What is happening? My Indian, kindly see, European conditions say train operates where there are parts, no one can come in. Indian operates by lot, level crossings everywhere. Now, to say, what are we talking about? Well, these wheels. If a chain comes in and if the chain is counted, our entire calculation will go wrong. That is why the trolley. In fact, their own document, I have not been given, will show that they have not tested trolleys in Indian conditions. Now, what are we talking about, Malad? We are talking about Indian conditions has to be complied with. European standards are not applicable here. Here, people travel outside the bogie. Now, to say that there is nowhere in the agreement that European standard will be applicable. European standard, the measurement of 80 mm new documents shown in Malad.
More like arguments outside the box. No? Yes. Mr. Ray, that is all.
Deeply.
Mr.
2 minutes.
Shaha, 2 minutes. You don't want that extra one?
It's 3 minutes. Yes, I want to.
Because they have filed your documents, you can address, but 3 minutes,
Well,
Mr.
3
Shaha, by the clock.
First of all, Indian conditions was my lord first pointed out in your lordship's first order where your lordship refused my lord injunction. They filed an interim report. Your lordship considered the interim report, all objections taken, my lord said they are, my lord, ultimately approved for Indian conditions. I have, my lord, disclosed in my, lord, note, my lord, the approvals, provisional approval first given, then it is tested on the tracks, supplied, assessed, and then, my lord, final approval given. So, my lord, it is, my lord, accepted for Indian conditions, number one. Number two, my learned submissions now made are, my lord, completely, my lord, bereft of, my lord, what he is stated in this pleadings. It is, goes completely beyond this.
Mr. Ray may have tried to make the matter simpler for me. That is all right.
Number three, my
Yes.
lord, the submission made with regard to detection points, track sections, my lord, that is not, my lord, mentioned in any of, my lord, the correspondence that was exchanged, my lord, in the context of, my lord, rejection, stoppage of inspection, whatever. Number four is, my lord, so far as, my lord, the documents that have now been annexed, I just want your lordship to have a look at, my lord, the affidavit that has been handed up now. My lord, kindly just see, my lord, 2 or 3 documents. Let me just show your lordship, my lord, the mischief, my lord, that, my lord, has now, my lord, permeated down, my lord, to this level. My lord, kindly see page 27. My lord, kindly see, my lord, this is a joint inspection that they are relying on. And my lord, the date is, your lordship will find 27th April 2023. Documents have been now being procured from, my lord, other persons, my lord, with the object of, my lord, influencing your lordship's, my lord, decision in this matter. Kindly see, my lord, 27th April 2023. And, my lord, this is obtained from, my lord, Siemens. Now, my lord, then, if your lordship will kindly turn over the page, my lord, page 29.
Yes.
28th April 2023. And then, kindly see, my lord,
These documents are for what purpose, Mr. Ray?
my lord, he tries to show from these documents that even on the basis of a single evaluator, my lord, testing, now, my lord, my learned friend continuously says, let him show his supplied 2 evaluators. I said, my lord, you need 2 evaluators for testing. And, my lord, it has been tested continuously on 69 times for thousands of pieces using 2 evaluators. When he says supply, I say if the railway wants 1, I give them 1. If they want 2, I give them 2 at no extra cost. And, my lord, then, my lord, kindly see, he now, my lord, tries to rely on other documents procured from what source, I don't know, which I have no opportunity, my lord, to deal with. And he says they have supplied you, they have tested using 1 evaluator. Well, maybe it's a different model. I do not know. But, my lord, kindly see at this juncture, they are, my lord, going ahead and obtaining documents.
What is this 33? This is the Supreme Court lawyer.
Well, before that, my lord, before that one is very interesting. My lord, kindly see page 31. Now, my lord, I had shown your lordship a document where, after your lordship's order, my lord, they had, my lord, pursuant to my last call letter, come and inspected following the acceptance test form and certified the goods. And then, my lord, they refused to give me an inspection certificate saying that you have harassed my men, you have not complied with. Now, my lord, kindly see, I have, my lord, the entire video recording of that inspection. My lord, they are happily, my lord, calling up people, talking, chatting, smoking. But, my lord, kindly see what they write here. And, my lord, this is again procured on the 4th of April. And this is not a part of the affidavit.
No, this is who is writing to who?
Well, this is, my lord, the inspectors who had passed my
Yes.
material. Now, my lord, there's a letter obtained from them saying that, my lord, they were prevented from, my lord, performing their functions.
No, they are writing to the RDSO.
To R3, respondent number 3, who was the, my lord, inspector who was tested 69 times. Now, my lord, these persons are deputed, they come inspect and they, my lord, then certify it. And now, my lord, there's a letter disclosed which says that, my lord, kindly see, my lord, the second paragraph. During inspection, we were forced and pressed to carry out inspection as per acceptance test format only and not as per specification, although a letter such and such was issued to the firm that inspection scheduled on 29th March will be carried out as per relevant specification. We were forced to fill up acceptance test format only and not other things about non-compliance. Well, what is this if not a procured, my lord, document from the persons who had inspected and passed? And then, well, very interestingly, well, this Mr. Bhomik, he says he's not concerned with any Supreme Court lawyer, any third-party complaint. Mr. Bhomik, my lord, Supreme Court lawyer, he, my lord, makes a complaint, which, my lord, apparently, my lord, activates, my lord, the entire RDSO.
No,
Now, my
but
lord,
this complaint is of 25th April.
yes. And, my lord, what does he write? He, my lord, writes that he was forced, harassed, but into withdrawing his complaint.
Harassed by who?
Well, apparently, my lord, the petitioners, my lord, person. But, my lord, well, I have just, my lord, inquired, said, my lord, this gentleman, in fact, approached him, my lord, in Delhi, wanted 25 lakhs of rupees to withdraw his complaint. 1 crore, I'm sorry, 1 crore to withdraw the complaint. And he has that, my lord, on record. He has recorded the entire conversation. But I don't want to go into that. Now, my lord, kindly see, my lord, this is, my lord, what is happening. They're generating documents now just to keep me out. Because otherwise, my lord, 1100 crores every year is, my lord, going to go to other pockets. Now, my lord, the last submission is, my lord, so far as, my lord, the
No, so this threatening me and my family members with dire consequences, that is, you are threatening him.
I am threatening him.
Yes.
A pseudonymous complaint. I have gone to him. I have found him out and threatened him to withdraw his complaint. After his complaint has set in motion, my lord, all these actions. What is
Yes.
the point of my my lord, now approaching him to withdraw the complaint? Because RDSO has, my lord, taken up, my lord, the matter with earnestness.
Yes. Anything else,
My lord,
Mr.
these are the
Shah?
submission. My lord, everything is there in my note. My lord, I think, my lord, this is an affidavit which has been procured. My lord, this affidavit contains documents, my lord, which have been manufactured, procured under what, my lord, duress or coercion, you do not know. My lord, this whole, my lord, affidavit is a completely dishonest attempt to, my lord, ultimately, my lord, take your lordship away from, my lord, the submissions and the pleadings that have already been made. And only one more thing, Since my learned friend, my lord, was handing up, my lord, no, Eastern Railway. Since, my lord, only one, my last submission. My lord, all the complaints are made by RDSO, not a solitary complaint made by the railways, and I have supplied to the railways. Now, my lord, I have on the 1st of May, yesterday.
You are an OEM
Yes,
supplying directly to the railways.
that's right.
But it has to go through the RDSO for the testing.
My product has to be approved by RDSO.
Very well.
Now,
Yes.
my lord, my learned friend, my lord, now hands up, my lord, this sheaf of documents. My lord, I have yesterday, my lord, been served with a letter of Southeastern Railway, my lord, which says that this is to confirm, this is certify that you have supplied evaluators, etc. This is to confirm that during installation as per required site conditions, 6 number of evaluators have been installed as per signaling and they're all perfectly working. Well, this is a certificate I received from the railways yesterday.
No, evaluators are men or machines?
No, well, evaluators are a part of, my lord, the machine. They're a
Very
part
good.
of the machine.
Yes.
And, my lord, they, my lord, ultimately reset it back to 0 after the wheels have passed and the wheels have been counted. That is all. My lord, I don't think, my lord, we should trouble your lordship, but, my lord, today what is important is
Mr.
RDSO
Shah,
complaints.
if Mr. Ray doesn't have the document, I won't rely on it. Yes.
Don't have to go there.
Learned counsel appearing for the RDSO has filed an affidavit containing documents in support of the arguments made to the court, in support of his arguments. Stop. The notes on behalf of the parties are also before the court. Stop. List this matter on 17th May 2023 under the heading for judgment.
Only one small request. My lord, my learned friend has used an affidavit. My lord, I have not used an affidavit, my lord, in reply. Kindly,
Mr. Shah,
only, my lord,
don't
the
file any
complaints are-
more, any
No,
further.
no, I'm not filing.
Yes,
Contents
Act
are, my
line.
lord-
Yes, what is it that you want?
I just say that, my lord, the contents are not admitted. The
Very
contents are denied.
well. Learned counsel
letters
appearing
and
for
contents
the
are all
petitioners submits that since the petitioners do not wish to file any reply to the railways affidavit, which has been filed today, to the RDSO's affidavit, which has been filed today, the allegations contained therein should be deemed not to have been admitted. Stop.
Grateful.
Deeply well. Item number 12.
12, my lord, I appear for the petitioner.
Mr. Doctor, microphone, please.
My lord, I appear for the petitioner. My lord, the answering.
The annexures are not there.
Yes, annexures are there, my lord. The affidavit is ready. My lord, the answering main respondent would be the
Affirmation
state.
also there.
Yes.
Yes.
And the main answering respondent would be the state. Mr. Nilotpal Chatterjee was here,
Yes, yes.
but he is not here. My lord, my only small grievance. My lord, I am a company dealing in horticulture products. My lord, I maintain and establish
What
cold storage.
horticultural products?
My lord, relating to plants and my lord, those are used as food products also. My lord, I
Like
maintain.
what? Give me an example.
My lord, one example would be a potato, but it is not directly a horticultural product. But
Potato is not a horticultural
yes,
product.
definitely
Mr. Bhatt.
not. My lord,
Yes.
there are certain, my lord, byproducts or certain parts of plant which are used as food.
Give me an example.
Spinach.
That's the best you could think of.
Well, I am not aware of what exactly they deal in, but that is what I am given to
Yes.
understand. My lord, we establish cold storages. My lord, there is a scheme in place by the state government as well as by the central government where I am supposed to get subsidy for this horticulture products which those companies deal in. My lord, I have been making representations since 2012 onwards for this subsidy. There has been previous rounds of litigation where this honorable court had directed the state government to consider this and pass an order whether I am entitled to a subsidy. I had complied all provisions, all their compliances, but they did not.
Subsidy under a scheme?
Under a scheme.
Under a scheme.
Under a
What scheme is that?
My lord, the scheme is named, my lord, it is named Mission for Integrated Development of Horticulture, and these are the operational guidelines.
Which page?
My lord, page 32. But I would not invite your lordship to into that.
No, only for my order.
Yes, yes,
I have to say something.
yes.
Yes, very well.
My lord, under this scheme, I am supposed to apply. My lord, there are separate projects where I am supposed to apply before the state government and before the central government. Central government is also a party, but the present writ petition doesn't concern about a project which I am supposed to apply for the central government. I had applied and my application was
No, so
considered.
the scheme, who will give you the subsidy?
My lord,
The
there-
state
my lord,
government?
Yes, in this particular writ petition, the issue concerns about the state government. This is a scheme of the central government where both the authorities are to supply or subsidize me for different projects.
Then why only the state government?
Well, this project concerns the subsidy which the state government has to give. My lord, I had applied. This honorable court had the occasion to consider.
Yesterday you said there is only a representation which they need to
Yes.
consider.
This
Yes.
representation they were to consider. My lord, they did consider pursuant to the earlier direction of
Who is
this
they?
court. My lord, this state government, the Department of Food Processing Industries and Horticulture. My lord, they did consider. Supplementary to that.
Lord, may I go through the supplementary and come back before your
My lord,
lordship?
I am presently, if Mr. Chatterjee gives me a moment,
Sir,
my lord, presently I am only concerned about they did consider this and pass an order. But this order only says that one of my affidavit
Yes.
is not as per the format.
Excuse me, one of your affidavits.
Yes,
Is
one
not?
of my affidavit as per the compliances where I was to make is not as per their standard or as per their format. My lord, if my lord is pleased to grant them time, I am not objecting, but they may
No,
come
where
back.
is that order?
My lord, this. What the number is it, Paul? One page, Paul.
177 বলছো?
No, minutes down.
Mr. Datta, hurry up. Where is that order?
আরে যেখানে এফিডেভিটটা নেই বলছি আরে পেজটা বল My lord, annexure 18B of the supplementary affidavit.
18B.
My lord, and yes, my lord, page number name.
You haven't even paginated it.
Yes. My lord,
What is going on, Mr. Datta?
I cannot.
But you should take a personal interest in what the way your matter is being presented. What is this?
My lord, I cannot say anything.
Yesterday I gave you time only because you were appearing.
My lord, I have no words to say, ma'am. My lord, let my learned friend consider this and come back.
Mr. Chatterjee, when do you want to come back?
May I come back day after tomorrow, my lord?
My lord, next week, any day next week.
Wednesday, my lord.
The learned counsel appearing for the petitioner is given leave to paginate the supplementary affidavit which has been filed in court today. Stop. Next, learned counsel appearing for the state seeks time to take instructions on the supplementary affidavit. Stop. List this matter on 8th or 10th. When do you want to come back?
10th, my lord, 10th.
On 10th May 2023 as prayed for.
I'm grateful, my lord.
I tender my unconditional apology.
Item number 13,
My lord, I'm appearing for the respondents, my lord. But today I'm praying for dismissal, my lord, because on the last two occasions also.
Last order.
This was taken up yesterday also, my lord. Last chance was granted.
Yes, the petitioners, the orders on record indicate that the petitioners do not want to proceed with the matter. Stop. The petitioners have sought for adjournments.
I'm sorry, my lord.
What is it?
I'm appearing for the petitioner in the matter, my lord. Very sorry, my lord.
I was about to dismiss it.
And rightly so, my lord. There's nobody here to even ask. I was briefed on the last day, my lord. I believe the matter had appeared before, and
Yesterday also.
I'm very sorry, my lord.
You want to do it today or come back tomorrow, day after?
May I come back to any day convenient to your lordship, my lord?
Well, in the meantime, my lord, may I pray for a direction for opposition, my lord, because disputed questions of facts are involved in this matter.
Very well.
They say the
Yes.
form has not been accepted. The form.
Section 186 disqualification. It's a section 186 of the Companies Act disqualification. Now the time will, my lord, run out very soon. Only order I'll pray for, my lord, is for these persons. They are, my lord, directors of certain other companies which are going into default. Now, my lord, if
Default?
I'm sorry, my lord, their names will be struck off. So, my lord,
For what reason? 186?
because a director with his DIN disqualified, my lord, is not able to upload. So, my lord, the annual returns, etc. So, without prejudice, my lord, only if that can be done, I'll work out the rest of the punishment.
Well,
Provided, my lord, there was, in fact, my learned friend,
Companies Act.
in fact, my learned friend was my other side in that matter. My lord, we had, my lord, not succeeded before, my lord, the learned single judge. Batch of writ petitions were, my lord, dismissed. There was an appeal filed. In that appeal, my lord, there is an interim order. In one of those appeals, there is an interim order. I will just have to, my lord, take it out to see whether I can take any advantage from that interim order of the division
That
bench.
was with regard to 14,
Yes,
15, 16. 89.
That's I would have found out, my lord. Suddenly, my lord, this
167.
and I believe, my lord, the
No, you said 186.
167.
Lord, may I just
167.
let me.
That's a disqualification, yes.
Yes, Lord, may I just study this and come back tomorrow, my lord? That's
Can it be taken on Thursday?
yes, yes, of course, of course.
Yes, or this is automatic vacation.
Automatic, my lord, I think I.
My lord, 164 read with 167 automatic vacation, my lord. They have been disqualified from 18 to 23, my lord. 1st November 2018 to 31st October 2023.
Very well. Mr. Chaudhary, that's up to you. You're saying that it can't wait for a long time. So tell me when you want to come back.
Whenever your lordship permits, my lord, any day, my lord.
8th? Yes, 8th is all right, Mr.
My lord.
Kankani?
I'm grateful, my lord.
Yes, যেটা আগে বলেছি কেটে দাও। Learned counsel appearing for the petitioners seeks time to get ready in the matter. Stop list this matter on 8th May 2023 as prayed for.
I'll just ask you.
Okay, okay. Grateful.
It's a closed chapter, I can't argue. I want.
ওই 11:30 টা ডাকো।
First over matter, item number 3, Tebrewaal Steels.
শোনো, the petitioners just 1 minute. Mr. Banerjee, who are 2, 3 and 4?
With the directors of my lord, the guarantors.
The
Guarantors as well.
the petitioner numbers 2, 3 and 4 are guarantors and directors of the petitioner number 1 company and seek a direction on the respondent IDBI Bank to accept a sum of rupees 2,25,51,833 from the petitioners towards repayment of all the credit facilities which are lying outstanding in the name of the petitioner number 1 and to the full and final satisfaction of the dues which are payable to the respondent bank. Stop. The respondent bank is IDBI, is the IDBI Bank Limited. Stop. It next paragraph, the last line. Hence, comma, the respondent bank has taken a point of maintainability of the writ petition, which should be considered first. Stop. Next, a learned counsel appearing for the petitioners has relied on Federal Bank versus Sagar Thomas, 2003, 10 SCC 733, where the Supreme Court summarized the position of maintainability of a writ filed under Article 226 of the Constitution in respect of 8 respondents. Stop. The 7th category was a private body discharging public duty or positive obligation of public nature. Stop. Federal Bank was relied on in a judgment passed by this court in WPA 11406 of 2022, within brackets, Olive Tree Retail Private Limited versus South Indian Bank, where the court was faced with a similar resistance to the maintainability of the writ petition. Stop. The issue also came up before a coordinate bench in Pearson Drums and Barrels Private Limited versus General Manager, Consumer Education and Protection Cell 2021 SCC Online Cal 503. Stop. The aforesaid decisions make it clear that a writ petition is maintainable even against a private bank if it involves enforcement of a statutory duty on the part of the bank, which involves discharging public duty or a positive obligation of a public nature. Stop. In the present case, the bank floated a special, the bank announced a special scheme of quotation marks, page 144 page ave, Amrit Mahotsav Rin Bhugtan Yojana, close brackets, by way of a press release, capitals, for the purpose of boosting its recovery efforts through a one-time settlement of NPAs up to rupees 10 crores. Stop. The scheme indicates, capital S, indicates that the benefit would be passed on to a large section of account holders whose accounts had become NPA. Stop. The scheme hence has a public element attached to it, and the bank is discharging a public duty which the bank is under a positive obligation to uphold and discharge, stop. These considerations persuade the court to hold that the writ petition is maintainable. Stop. Next. With regard to the merits of the matter, stop, comma. The petitioner, the account of the petitioner number 1 was rendered, became NPA in 2017, and the bank initiated proceedings under the SARFAESI Act by issuing notices under sections 13 within brackets 2 and 13 within brackets 4 of the said Act. Stop. The bank also approached the Debts Recovery Tribunal in 2018. Stop. The stand taken on behalf of the bank is that the petitioners should go before the DRT and contest the pending proceedings. Stop. Having held the writ petition to be maintainable on the grounds stated above, comma, on the reasons stated above, comma, this court is of the view that the present writ petition, that the petitioners have a right to approach the writ court for seeking a mandamus on the bank to discharge its obligations under the scheme. Stop. This is particularly so. This is particularly where a learned counsel appearing for the bank submits that the scheme, capital S, does not have a fixed timeline or an end date. Stop. Next. The records placed before the court shows that the shows that the upfront payment of the one-time settlement amount was to be payable on or before 28 February 2023. Stop. The writ petition, however, encloses a mail from the bank to the petitioner dated 1st March 2023, stating that the mail is being resent, stating that the bank is, quotation marks, resending, close quotation marks, the sanction letter as requested. Stop. The mail encloses the bank's letter of 31st January 2023, stating that the petitioner is eligible for OTS under the scheme towards full and final settlement, subject to the petitioner's unconditional and absolute acceptance of the sanction and settlement of dues. Stop. A learned counsel appearing for the petitioners submits that the petitioners received the mail only on 1st March.
Yes.
Only on 1st March 2023, and did not receive any mail on 31st January 2023, and that the resending, quotation marks, resending is an incorrect statement, and that Resending of the mail is an incorrect statement. Stop. Next. Since the bank has already informed the petitioner of its eligibility under the scheme, comma, the only dispute is whether the petitioners received the mail before, prior to the date on which the petitioners were to make its payment, make its payment under the scheme. Stop. The bank has not been able to show any document to substantiate the fact that the petitioners were aware of the scheme at any time before 1st March 2023. Stop. Hence, comma, the conclusion, hence, comma, the court must conclude that the petitioners only became aware of its eligibility under the scheme on and from 1st March 2023. Stop. Next, if that be the case, comma, the petitioners must be given an opportunity to pay the admitted amount which the petitioners are due to make towards the bank, to the bank and towards the scheme in question. Stop. The admitted amount, comma, from the bank's own documents
Page 148.
is rupees প্রথম যেটা বললাম 2, হ্যাঁ 22, isn't it? Or is
225 51 833.
Yes, 2225518.3.
It's been a 33, not 3.3.
22551833. Page 148 আর প্রথমে বোধহয় বলেছি না এটা। হ্যাঁ, স্টপ। এটা পেজ 144 এও আছে, দেখে নেবে। পেজ না 144 না, yes 148 এই আছে। 2,25,51,833. Stop. The bank, this figure has not been disputed by the bank. Stop. The petitioners are hence the petitioners, it is therefore held that this court is therefore of the view that the petitioners should be given an opportunity to make payment of this amount to the bank in pursuance of the conditions of the special scheme and by way of a one-time settlement of the petitioner of the account of the petitioner number 1. Stop. Next, WPA 7924 of 2023 is accordingly disposed of with direction on the respondent bank to receive and accept the amount of rupees 2,25,51,833 per F থেকে পেয়ে যাবে from the petitioners towards payment of the petitioners' credit facilities which are lying due and payable to the respondent bank and to the full and final satisfaction of the outstanding amount of the credit facilities. Stop. The petitioners shall make this payment within a period of
A week.
within 7 days from date. Stop. It should also be noted that the eligibility of the petitioner for the scheme in question was already recorded by the bank in its letter dated 31st January 2023. Stop. The writ petition is disposed of in terms of the above.
Extremely grateful, my lord.
আর প্রথমবার দিয়ে মাঝখানে OTS দিয়ে ব্র্যাকেটে দিয়ে। Yes, call on the next matter, please.
Order book পাঠিয়ে দেবো নাকি? Order book টা পাঠাবো? না সব পাঠিয়ে দেবো, সব পাঠিয়ে দেবো।
ওই judgment গুলো লাগ
Item number 14 for the petition number. That matter, my lord, the cost has been given, my lord. I don't know whether they are paid or not.
May it
Yes.
please your lordship.
Yes, what is the matter?
My lord, the matter is, my lord, we are the land losers, my lord.
Yes.
We have to go get our name enlisted in the exempted category. For
What
this
category?
exempted category.
Exempted category.
But as a beneficiary. But on the last occasion, they have on the 4th September, they want to file opposition. Last on yesterday also, they have also decided to give the fine, the cost.
Have you paid the cost?
No, my lord. My lord, on the several occasions, my lord, I tried communicating with the department. Just 10 minutes, and I have sent the
What department?
my lord, the respondent, my lord. I have sent it to the available email IDs and the phone numbers.
Which respondent? Which department? You're appearing for the state. Which
I am
department?
My lord, I have communicated this to the district magistrate office because the land acquisition officer's email ID and the phone number was not available there. 10 minutes back, I have received a message from the land acquisition department that they intend to file affidavit praying for 15 days time. I bow down before your lordship.
They paid the costs or
Oh,
not?
my lord.
This is the main thing.
Because their contention is they have not received. This is for the first time ever they came to know about the order. Though I have communicated to the available email IDs, which was of district magistrate and the labor department secretary, and no other email IDs or phone numbers were available on the Sharthok. That's why I couldn't communicate.
Very well.
Well, this has been going on since September, my lord. I'm very much suffering, my lord.
And today I have received the message on my mobile
Yes,
number.
learned counsel appearing for the state respondents submits that the respondents have neither filed an affidavit in opposition as directed by the order dated 5th September 2022, nor furnished, nor put in the costs in compliance with the order dated 12th April 2023. Stop. Council seeks a further extension of 15 days to file the affidavit in opposition. Stop. It is submitted that the concerned respondents were not aware of the orders passed by the court with regard to filing of the affidavit in opposition. Stop. Next, the orders on record show that the matter has been pending since August 2022. Stop. The matter has been pending before the court since August 2022, and the petitioner was not granted any interim protection on the consideration that the state should file its affidavit in opposition. Stop. This direction was given on 5th September 2022. Stop. Extensions were taken on behalf of the state on 29th March 2023 and on 12th April 2023. Stop. The state again seeks an extension today. Stop. There is, it is also evident that costs have not been put in as directed by the court. Stop. Next. Affidavit in opposition to be filed by 12th May 2023 upon further costs of rupees 20,000 to be put in, to be paid by the state respondents to the petitioners. Stop. The payment is to be made within 8th May 2023. Stop. List this matter.
I'll make the deal.
Reply to be filed on
15.
by 15th May 2023. Stop.
16.
List this matter on 16th May 2023. Stop. The state, learned counsel appearing for the state shall give evidence of the costs of rupees 20 plus 20,000 on the next date, on the returnable date.
Grateful, man.
Item number 15.
15, my lord, I am for the petitioner.
I am appearing for the state respondents, my lord.
My lord, the affidavit of service may be kept on record.
Evidence by the orders of this court, on the returnable date. Yes.
My lord, the fact, the petition
I
relates to
can't
the-
hear you.
My lord, a 10-year-old child. The petition relates to the petitioners are the paternal aunts of the petitioners are the paternal aunts of the 10-year-old child who is residing in a home. He has lost his father. His mother is very reluctant in taking care of the child. She herself wrote it before the authorities of the home and everybody. And my lord, the child is in the home.
How many aunts?
2 aunts, my lord. And my
Yes.
lord, the child is in the home on the with the help of
your
the
father?
CWC, my lord.
I'm appearing for the respondent number 2, the child welfare.
I can't hear you. Microphone.
My lord,
please.
I'm appearing for the child welfare committee, my lord, and
Yes,
the
what do you
state
have to say?
respondents. My lord, I would like to use an affidavit in
Why?
this particular case because, my lord, the child welfare, there has been several allegations made against the child welfare committee in particular. My lord, the child welfare committee has taken all steps with due
I
regard.
can't hear you.
My lord,
Don't
the
you know
child,
how to use it?
my lord, the child welfare committee has taken all the steps with due regard and by following the
All
process.
steps. I can't
My lord,
understand. What allegations? What steps?
my lord, the allegations that the petitioner has made is with regard to visitation, is with regard to providing outside food to the child while the child is at
No.
the foster care, and with regard to access to the child on a regular basis. My lord, these allegations that have been made that cannot be complied with regard to one particular individual, because in that home there
No,
are several.
there are I think two aunts.
2 aunts, my lord. My only my only prayer is we just want
One
to have
minute,
access to
Let
the
me
yes.
hear him. Yes.
My lord, and the fourth point is with
No,
regard
why
to.
don't you want to give visitation rights?
Well, I am not coming in the way of granting visitation rights,
Yes.
but the visitation rights
How
have
old is
to.
a child?
My lord, the child is 10 years old.
10.
Yes, my lord.
So what is the problem? The child will continue to be in the welfare.
My lord,
home.
I have no problem with regard to maintaining the child at the welfare home. The child can remain in the same with the same rights and benefits as all other childs. Here, the petitioner, my lord,
Children. Yes.
with all other children, my lord, I apologize. But here the petitioner is trying to make out a case where this child particularly is taken out for the purpose of giving certain benefits which the other child will be deprived of. And also the petitioner is seeking certain information with regard to adoption of the child or of surrender of the child, whereas the biological parent, the mother is
So as
still
an
alive.
interim measure, you give visitation rights
My lord,
and
the-
then
my
whether the
lord,
child
she
can
can-
be taken away, that's a different, that's a later question.
She can come during the regular hours. She can come and visit the child. She is trying to make phone calls and asking to talk to the child at any hour of her convenience. My lord, all these extra benefits could not be
Very well,
met out.
you suggest a time when the petitioners can visit
My
the
lord,
child.
I am only
1
seeking,
minute, please.
my lord,
Yes.
I'm only seeking, I have already sought instructions. My lord, if I can file an affidavit within 7 days, and thereafter, my lord, I will also take
What will the
instructions.
court see? What affidavit? I'm just telling you, before you file that affidavit, you indicate when the petitioners can visit the child, and that
But there
order
is an
will
issue with
pass.
regard to maintainability with regard to the petitioner's application, because the mother is alive. The petitioners, since 2020, the child is at the home. The petitioners have neither come forward to obtain foster care for the child, neither are they the legal guardians.
I am not directing you to release the child to the petitioners, just visitation.
My lord, visitation, my lord, in that case, my lord, kindly keeps it after 2 days. I'll just take instructions whether there is any restriction on the visitation, because according to me, my instructions that I've received, but it was only verbal instructions that regular visitation they can avail of. There is no problem with regard to that. They, at page 17, my lord, they have pointed out the 5 grounds on the basis of which they are seeking.
Yes.
They are seeking their representation is on that basis. My lord, the first at page 15, my lord.
Yes.
We humbly pray with regard to the first point to allow Rajiv Dey to stay in a secured environment at Ashirwad home. We are willing to full
Where is
sponsorship.
the child here? Not at Ashirwad home.
He's in no, my lord, he's no longer in Ashirwad home. He has been shifted to the CIC male boys hostel, which is under Hope Foundation. It's the same organization, but a different
Hope Foundation.
Yes, my lord. Hope Foundation, Ashirwad Home is also under Hope Foundation, and so is this particular institute.
Very well. So what is so disturbing about 17?
lord,
It's fine.
The full sponsorship,
Yes.
my lord, since when the child comes under the protective custody of the state, the sponsorship can either be done by the NGO in cases of aided institutions. It can be done by the NGO.
Very well. I'm not asking you to say the yes to the sponsorship. I'm just saying that whatever visitation rights the petitioners had before,
Yes, my lord.
filing the writ petition, you continue with that.
My lord will kindly keep it tomorrow. I'll just take instructions, and I believe that it is in process. They can visit at the same hours. I am not restricting the visitation rights at all.
Yes.
My lord,
I'll just take instructions and come back.
my
tomorrow.
humble submission before your lordship is this: the prayer what my learned friend has said.
Microphone, please.
My lord, what my learned friend has submitted all is not true. Your lordship can see the prayers over here.
No, just tell me what is it? You just want to visit the child.
Yes,
That's
we
all.
want to visit the child, and what we used to do at regular intervals when the particular day when it was his birthday, we some gifts, some
Yes,
food
yes,
like that.
yes.
But
Yeah, I'm
the
keeping it
home
tomorrow.
is, my lord, the home is not allowing us because they said that they have the instruction from the CWC that other than biological parents, we won't allow anyone to visit the child.
No, the father has
This is the
died.
thing.
Father has died.
Father expired and mother, my lord, your lordship may kindly remember if your lordship kindly comes to page number-
what has happened to the mother?
Mother is there. Mother is, I
Page number
think,
16,
I
my
believe
lord,
mother is dependent on an aunt, and the mother can come and visit as well. There is no issue, but the mother
Why are
doesn't
you
come
so
forward.
keen? The mother doesn't want to
My lord,
visit the
kindly,
child.
my lord, kindly comes to page
Please,
number 16. No,
answer the
mother is
question.
very reluctant to take care of the child. She has given a note and she has intimated the same to the Hope Foundation and also to
And
the
one of you are looking after the mother.
No, she
No.
doesn't. She is not in contact with anybody in the family.
My lord, may I say, my lord?
Who are you?
I am for the Hope Foundation, my lord. I am for the Hope Foundation, my lord. There is only one on 2022. My lord, the mother came to my home and consent to the child to visit to the Shanti Niketan.
What?
Opposite, my lord, the petitioner says, my lord.
Please reframe your sentence. Yes.
Petitioner, my lord, says that the mother is reluctant to take care of the child. But that's not true, my lord. The Hope Foundation has the documents where
You're
the
appealing for the Hope Foundation.
Yeah, my-
Very well. You're saying that the mother is
mother
keen.
is regularly touch with us.
Yes, learned counsel appearing for the CWC. Kolkata. And seeks 1 day's time to take instructions with regard to permitting the petitioners to visit the child in the same frequency as the petitioners were doing before the matter came to court. Stop. Next, list this matter tomorrow. Stop. Learned counsel appearing for the Hope Foundation submits that contrary to the position taken on behalf of the petitioners, who are the maternal aunts of the child, the child's mother is in regular contact with the child. Stop. List this matter tomorrow as prayed for. Next.
Item number 16.
I appear
Would I appear for the petitioner?
Yes.
Would I appear for the petitioner?
Yes.
But this pertains to, my lord, a notice inviting tender, my lord, which was issued by the Damodar Valley Corporation, my lord, for the empanelment of transportation agencies, my lord, to remove the ash. Now, my lord, I had participated in the bid. And my lord, there's a
How many matters? Isn't there another matter where there is some charge of suppression? That's a different matter.
my lord, I am
Removing ash, same thing. Removing ash and putting them in some ash pond or something. Yes.
no, it's removing from the ash pond and taking to somewhere
Very-
else.
yes.
Now, my lord, here, my lord, I had participated, and my lord, in the reverse auction, my lord, again, my lord, I was successful. Now, my lord, the entire work was, my lord, divided amongst, my lord, 4 of the bidders. I am one of those 4. So the total quantity which is given to me is 25% of the required ash to be removed. Now, my lord, before proceeding further, my lord, my allegation is that, my lord, I am supposed to, my lord, provide trucks and transport. My lord, the system at the local is that whoever is the successful bidder, he or she has to get the trucks hired from, my lord, the local transport, syndicate as they call. Now, this has also prevented, my lord, the local transporters are so, my lord, influential over there that it had influenced, my lord, even
There, which is the place?
But this is Mejia. This is at Bakura. Now, my lord, this organization or this body, my lord, is not giving me trucks for which, my lord, I could not, my lord, start the work.
So giving trucks to the others, not you.
He's not giving it to me. Now, my lord, before I come to my problem, kindly see the same problem which the DVC had faced while, my lord, finalizing the tenders. Please have a look to, my lord, page 195.
No, but not a party. What is it? What is the prayer?
Say,
Not a
the
party.
name is Durlapur Truck Association. No, I don't think
No,
it is
not a party.
No, it's not a party. It's not a party because
So
today,
what is the
Milord,
prayer?
today, Milord, I am facing, Milord, a debarment because I could not supply the trucks over there for transportation of the ash. Now, Milord, this is a problem, Milord, which I cannot solve. And this is a
So you want the suspension letter to be quashed?
Yes. Now, why I say this? Milord, it is first the DVC who had faced the problem. Now, please take Milord, page 195.
No. Where is the suspension letter?
Yes. Now, Milord, so far as the suspension letter is concerned, Milord.
6 March.
Yes. This is 258. Where it was preceded by a show cause notice. Now, please take, Milord, the last paragraph at page 259.
Yes.
Therefore, as per the provisions of clause 24.2.2b of GCC, that is termination for contractor's default, and documents and documentary evidence available, in support thereof, and the subject contract under reference so and so has been terminated on 15/9/22 on your default with immediate effect. And the show cause notice for suspension of the business dealings was served, video, etc. as to why you will not be
You gave a
suspended.
reply.
Milord, they had not considered my reply. That would be evident, Milord, from the next sentence or the part of the next same paragraph. In response to the notice served with a show cause dated so and so, cited reference to your reply, received with a letter number under reference 1 is not satisfactory. Now, this is the total application of
So
mine.
what is this? Bids will be rejected. What is this?
Milord,
Next paragraph.
yes. Now, what they do is they not only suspend me, Milord, from participating in future contracts,
But also blacklist.
blacklist me to the extent that in the bids where I have participated, which has not yet, Milord, been finalized, there also, Milord, my bids, which are in the process of consideration, those will also not be considered, which were not in the show cause notice. Now, Milord, the problem which, Milord, had prevented me, Milord, from undertaking.
What is the interim order you want?
Milord, for the present, Milord, I am seeking, Milord, stay of this at page 258, 6th of March 2023.
Yes.
Yes, my lord. My lord, first, my lord, I invite your lordship's attentions, my lord, to clause 6.2, my lord, at page 71 of the NIT, my lord. It's 71. 16.
Yes.
Performance security, security deposit cum performance guarantee. Within 30 days from the date of issuance of letter of award, work order from respective project, the successful bidder shall furnish performance security for satisfactory execution of the order for an amount equivalent to 3% of the letter of award and or work order value in the form of an unconditional bank guarantee as provided in the section bid forms and procedures of the bidding documents from any nationalized and or scheduled bank as per the list provides is annexure 1 of ITB, and it should have valid.
This is not the clause. Show me the
Yes, my lord.
penalty
Then, my lord,
clause.
then, my lord, 16.2. Notwithstanding the provision specified, if bidder, after having been issued the letter of award under work order, either does not sign the contract agreement or does not submit an acceptable performance security, the bidder shall be suspended for 1 year and shall not be eligible to bid for DBC tenders from date of issue of suspension order. Till date, my lord, the security deposit, my lord, has not been submitted by the petitioners, my lord. That is the only cause, my lord, for suspension.
And therefore, they have not signed the contract also?
Yes, my lord.
Yes. Very well. Anything else?
And they have got 2 count, my lord. First, my lord, that they failed to submit the security deposit bank guarantee, and which was required to be submitted within 30 days from the date of passing of the letter of award, my lord. Even after passing 125 days before filing the writ petition, they have not submitted this bank guarantee. So thereby, my lords, this tender is liable to be, my lord, suspended, my lord. So in exercise of this power, my lord, this was done by the DBC. And secondly, my lord, so for the commencement of the work, my lord, I will invite your lordship's attention clause 24.2.2, my lord, at page 107. 108.
Yes.
24.2.2, if the contractor B has without valid reason failed to commence work on the facilities promptly or has suspended other than pursuant to GCC subclause 24.2, the progress of contract performance for more than 28 days after receiving a written instruction from the employer to proceed. So terminations may be made, my lord, if they do not commence the work, my lords, within 28 days from the date of
No, you
instruction.
have not terminated, you have suspended.
Yes, my lord, no. Termination and
Termination is
suspension,
now-
both, my lord. Because suspensions was made, my lord, in exercise of the power conferred under clause 16, my lord, and terminations was made in exercise of the power conferred under clause 24.2.2. And my lord, first instructions was issued, my lord, that would appear, my lord, at page 205, my lord.
205 is what? Sorry?
my lord, the first instruction, my lord, because 28 days from the first instructions, my lord. That is at page 2005. Through a mail, my lord.
Very well, that is fine. Yes.
Yes, you are
Mr.
requested.
Mr. Dotto, I don't see any ground to give you interim relief.
May I say this?
You are completely covered, or rather, you are uncovered by 16.2
Yes. My lord,
and 24.4.
my lord, 16.2 was never invoked by them either in the termination or, my lord, for suspension, that you have not submitted the bank guarantee.
Two things, Mr. Dotto, sorry to interrupt you.
Yes.
One is your non-furnishing of a performance guarantee, and thereby you're not signing the contract.
Right.
16.2.
Right. Number, the first ground which has been argument advanced by my learned friend, that is not a ground of either termination or suspension. Therefore,
Yes.
my lord, unless, my lord, the respondents take recourse to that clause,
Yes.
but in a very respectful submission, my lord, that cannot be, my lord,
Take recourse to
supplemented.
which clause?
They chose only 24 by 22.4.4.
Not 16.2.
No. Please have a come back to me.
But do you have a defense to 16.2?
Yes.
What is the defense?
The defense is the problem that they had faced is the problem which I have faced. Now, what problem did they face? Millard, kindly have a look to Millard, page 195. I'm so sorry. Please have a look to this, Millard. But they could not finalize the tender because of, Millard, this agency. And I suffer from the same problem. There are at least 10, Millard, on record.
No. But are you saying that you should be given more time to not 28 days under 24.4?
Millard, my problem is, Millard, unless, Millard, the truck owners or the association over there, Millard, provides me trucks, but I cannot.
What
Millard,
about the other three bidders? You are one of the four, you said.
Yes, I am one of the
25%.
Millard, yes.
What about
Please
the
take
others?
Millard, page 195. Kindly have a look to this, Millard. It is their document.
Yes.
Millard, this is the award of the work after reverse auction. Millard, the table at the middle of that page. Kindly take, Millard, the next one. DVC awarded the work order in the name of the above mentioned bidder on 12/4/22. Work required to start immediately upon issue of the work order. But due to objection of Gautam Mishra, President of Durlabpur Truck Owners Association, till date it is not possible to start the work by the L2, L3 and L4. I am L4. But this is acknowledged by them. And Millard, I am being, Millard, penalized for the same reason.
No. This is what is this? This is a work order. What is page 195?
Millard, after Millard, the price bid was open.
Yes.
Millard, pursuant to the reverse auction, Millard, they found 4 people to be.
No. What is page 195?
Millard, this is a document, Millard, which is found, Millard, on their website, which has been uploaded by them, Millard, after the price bid was opened and the reverse auction was done.
Yes.
Now, DVC says that because of the objection of this association, they could not finalize the tender. Why? And who are the affected?
But the tender was finalized after that.
No, it was finalized before that, but there was a delay in finalizing it because of the objection of the local transporters.
Very well.
And they say that
Mr. Dotto, they will file an affidavit to say what you are saying, and then we will see. Yes, the petitioners seeks stay of a notice dated 6/3/2023 issued by the Damodar Valley Corporation, which is a notice which gives effect to DVC's decision of suspension of business dealings with the petitioner firm for 1 year, and also barring the petitioners and also prohibiting the petitioner from participating in any tender inquiry. And tender inquiry. Stop. The impugned document also records that in the event the petitioner has participated, the petitioner's bids will be rejected. And the petitioner shall also not be allowed to participate as an associate for any of the tenders of DVC. Stop. Next, upon hearing learned counsel appearing for the parties, it appears that the impugned notice was premised, is premised on clause 16.0 of the tender documents dated 30/11/2021.
May I interrupt, my lord? Subject to correction, but 16.0 was never invoked. So far as
Very well. For empanelment of transportation agencies, for evacuation of ash from ash ponds of the Megia, MEGIA, Megia Thermal Power Station. Stop. The, although, comma, the letter does not, the impugned notice does not refer to clause 16.2, comma. Admittedly, comma, the petitioner number 1 has not signed the contract agreement till date and has also not issued the, and has also not submitted a performance security within the time mandated under clause 24.2.2 within brackets B. Stop. The impugned letter mentions clause the impugned letter mentions issuing, it mentions a show cause notice issued to the petitioner and a reply given by the petitioner to the same. Stop. The impugned letter also mentions clause 24.2.2 within brackets B of the general conditions of contract. Stop. Next, learned counsel appearing for the petitioners submits that the petitioners were unable, that the petitioners were declared as one of the 4 successful tenderers and was given 20, and the petitioners were accordingly given 25% of the work to be performed under the tender. Stop. The petitioners were, however, unable to perform the work by reason of a local transport agency named Durlavpur, DURLAVPUR, একটা কথা, Durlavpur Truck Owners Association, which prevented the petitioners from carrying out the work. Stop. Council submits that this agency has been mentioned by DVC itself in as part of the tender documents. Stop. Next, having considered the material on record, comma, this court is not inclined to grant any interim protection to the petitioners. Stop. On the ground that the impugned notice, comma, prima facie, comma, appears to have been issued under the terms of the tender/GCC. Stop. The matter shall be considered further. Final relief. The issue of relief will be considered only after affidavits are filed by the parties. Stop. Affidavit in opposition.
By 4 weeks, my lord.
Within by 10th May 2023. Do you want a longer date, shorter date, Mr. Doctor?
Shortest possible.
Reply by 5th May 2023. Stop list this matter on 16th May 2023.
7 days.
But only one, if I may pray, Miller, the bids in which I have participated, at least if those could be considered, not finalized, but if those could be
Is
considered.
that part of that clause?
Yes.
16.0?
No, it is not part of 16.0. This provision is nowhere.
Yes, it is made clear that DVC shall not give effect to any penalty as stated in the impugned letter, which does not form part of the clauses in the tender condition. Stop.
I'm grateful.
Second.
Item number 17. Item number 17.
Milord,
17, my lord, I appear for the petitioner. This is same matter, my lord, only to the extent, if your lordship kindly comes to, my lord, the impugned order.
Give me the page number, please.
My lord. My lord, kindly comes to, my lord, at page 254. My lord, I stand corrected, 248. My lord, the impugned portion, my lord, is at page 250.
Yes.
My lord, may kindly see, my lord, subpara Roman small 5.
Yes.
In view of the above, we are constrained to take decision of suspension of business dealings with your firm for a period of 1 year from the
No,
date of
I've read all this. What is it that you
the
want?
next part is, my lord, the impugned, where, my lord, they have not only prevented me from future tender, but also prevented me in respect of the tenders which I have already participated. And these two tenders, my lord, are part of this petition, where, my lord, they seek to debar me so that, my lord, I cannot be considered.
Very well, but no interim protection. Same as the last order.
But just may I just show to you, lord, the show cause notice, the show cause
No,
notice,
no,
my lord,
sir.
did
No,
not
no.
even
Affidavits,
even
and then I
started
will hear the
this.
matter. No interim protection.
Very well.
Yes, this matter is factually similar to WPA. देखने में आगे matter था. Stop. There is no scope for any interim protection. Stop. Affidavit in opposition. ওই একই dates দিয়ে দেবে 16th. আর ওই একই condition দিয়ে দেবে. The DVC shall not impose any penalty. একই. Next.
I'm grateful to your lordship.
I'm grateful, lord.
Item number 18.
But I appear for the petitioner. This is I'm sorry. Fine.
I appear on behalf of the respondent also.
On the last occasion, your lordship was pleased to direct Mr. Bhattacharya to take instruction as to the fate of the hearing which took place in December.
My lord.
No, I've forgotten. What is
This is, my lord, the passport of the petitioner was seized.
Yes, Mr. Bhattacharya.
My lord, I have taken instructions. My lord, the hearing that was granted, my lord, pursuant thereupon, my lord, the passport of the petitioner, now that was issued by the Embassy of India in Tokyo. My lord, the hearing of my lord, pursuant to the hearing and my lord, on further verification, my lord, decision has been taken, and my lord, on 29th of March 2023, my lord, a request has been forwarded by the Assistant Passport Officer, Regional Passport Office in Kolkata, to the Embassy of India in Tokyo, for impounding the passport of the petitioner.
Then, my lord, that decision has to be communicated to me.
Yes,
My level decision. That was never communicated to
If
me.
it is 29th March, Mr. Bhattacharya, why have you not informed the petitioner of
No,
this?
I'll tell your lordship, my lord, the difficulty. But this question also struck me, my lord. I asked that why the Embassy of India in Tokyo, because
Yes.
you afforded the hearing. So they said that no, impounding has to be made by the authority which has issued the passport. So the passport herein of the petitioner, now this was issued by the Indian Embassy in Tokyo.
Yes.
So, my lord, what my lord can do, my lord, I'll humbly beseech your lordship, my lord, may kindly pass orders, my lord, expediting the decision. Because as I find, my lord, there are two difficulties. This, my lord, this particular case, my lord, I will say, my lord, as it transpires, my lord, from what has been stated herein and from the, my lord, the instructions that I have received. Now, my lord, the petitioner did not know that she is not a citizen of India. Her case is that she had knowledge that her mother is a Bangladeshi citizen, but she did not have knowledge that her father is a Bangladeshi citizen. Now, the Bangladeshi passport of the parents, of both the parents of the petitioner, now those were shown to her and she did not deny. But in terms of the amended rules, in terms of the amended provisions, but there is a presumption that when a passport is obtained of another nation, then the presumption is that the person concerned who is obtaining the passport of another nation, another country, has acquired the citizenship of that country.
No, you're saying the petitioner's parents are Bangladeshi nationals.
Yes, and my lord, by virtue of my lord, a particular period of stay in India, if citizenship has to be applied for, my lord, there is no application. Now, my lord, the MHA, the Minister of Home Affairs, my lord, they had forwarded a request to consider that angle also. But as on date, my lord, there is no application.
So who gave the hearing to the petitioner?
But the hearing was given, my lord, in so far as, my lord, the passport is concerned. My lord, the passport authority was, my lord, the Assistant Passport Officer, Regional Passport Office, Kolkata.
No, so this authority gave the hearing.
Yes, I'll tell your lordship, my lord, very briefly.
Mr. Bhattacharya, 1 minute. You mentioned Tokyo.
Hearing was, my lord, I'll tell your lordship, my lord, there was, my lord, a lookout circular issued, my lord, as against the petitioner. But in so far as, my lord, the petitioner is concerned. Now, that was issued by, my lord, the Foreign my lord, Registration Office, FRRO. Now, pursuant to that lookout circular, the petitioners, my lord, she was detained. And the lookout circulars, the basis of issuance of the circular was that both the parents of the petitioner, they are Bangladeshi nationals. So, as a consequence thereof, the passport of the petitioner has been obtained by virtue of Section 10 of the passport.
But didn't you say that the petitioner was apprehended in Tokyo?
No. The passport of the petitioner was issued by the Indian Embassy in Tokyo.
Very well. And where was the petitioner apprehended? Where was she prevented from traveling?
Malad, she was prevented, Malad, in India only, Malad.
From leaving India?
No, while she was returning back from.
So I thought lookout circulars are to prevent flight outside the country. This time you are preventing somebody to return to India also.
No, Malad, I'll just mention, Malad, what was stated in the lookout circular, Malad. The lookout circular was issued by the Foreign Registration Office, stating that the moment, Malad, this particular petitioner's passport is presented, immediately.
Very well. Mr. Bhattacharya, have you taken a decision to impound the passport?
Malad, the decision to impound the passport has been, Malad, forwarded to the concerned issuing authority, Malad, in Tokyo. So, Malad, I was requesting, Malad, if Malad, that process can be expedited, Malad.
Bhattacharya, answer the court's specific question.
Malad.
Who took the hearing? Number one.
Malad.
Who took
the hearing was, Malad, the Assistant Passport Officer, Regional Passport Office, Kolkata.
Very well. Who took the decision? Same authority.
But same authority has taken the decision and forwarded, but it's a recommendation, forwarded the recommendation to the issuing authority.
Issuing authority is who?
Issuing authority is, Malad, the Consular Officer, Embassy of India, Tokyo.
And when was this done?
But this was done on the 29th of March, 2023.
March is the date of the order, is the date of the decision. When was it forwarded?
When was, no, this was forwarded, this is the date and this was forwarded video, email dated, I'll tell your lordship. The email was dated, 30th of March, 2023.
So why are you dragging your feet, Mr. Bhattacharya? Why will you not inform the decision? At least let the petitioner have a copy of the decision. Then I think it's an appealable decision. That
it is appealable, my lord. But for that, my lord, there has to be, my lord, the culmination of this particular recommendation. But this has to reflect, my lord, in the decision. The ultimate decision.
How much time will I give you? So the petitioner has the order in her hands. How much time do you want?
My lord,
take steps, expedite.
Yes, ma'am. I will, madam. my lord, I submitted, I volunteered, my lord, then my lord may kindly expedite this, my lord.
7
My lord,
days?
7 days, 10 days, my lord.
And you are appearing for FRR?
My lord, I am appearing for, my lord, the Union of India and all the authorities, my lord, apart from the, tell your lordship, my lord. Yes, respondent numbers 1 to 6.
The learned DSG appearing for the respondents, including for the Bureau of Immigration Capitals, comma, the Foreigners Regional Registration Office, as well as the Regional Passport Officer, comma, submits that the Assistant Passport Officer, comma, Regional Passport Office in Kolkata took a decision on 29/3/2023 for impounding the petitioner's passport. Stop. The said decision has since been forwarded to the passport issuing authority.
The consular officer, Embassy of India, Tokyo.
Has been forwarded to the passport issuing authority, namely the consular officer, comma, Embassy of India at Tokyo, to take necessary steps in the matter. Stop. Next, since the writ petition was filed for permitting the petitioner to travel to Japan to be with her infant daughter, comma, the petitioner should be given leave to file appropriate proceedings under the Passports Act. What is this, 1967?
It is 1960.
1967.
What is the full form of the act?
The Passports Act 1967.
The Passports Act, comma, 1967. Stop. Next, WPA 7510 of 2023 is disposed of with a direction on the respondents. Who will expedite, Mr. Bhattacharya?
My lord, can direct, for the consular officer is not a party, I find. So, my lord, can direct, my lord, the respondent number 5, my lord.
By directing the regional passport officer, comma, Kolkata, to ensure that the decision of impounding of the petitioner's passport reaches the petitioner within 7 days from today.
Well, only one prayer, my lord, just one prayer. My lord, if we prefer an appeal, this is an appealable order. If we prefer an appeal within 7 days thereafter, well, the appeal may be disposed of within 4 weeks thereafter.
Mr. Mojumdar, I cannot pass an order on a prayer which is not there before me.
We were not aware. My lord, and one more thing.
Mr. Mojumdar, you will have to take up proceedings after you get that order.
Yes.
I cannot, on the presumption of what that order is, I cannot pass that order.
I fully understand. And only one submission, since learned Deputy Solicitor General is online. My lord, today the matter has been, the recommendation has been forwarded to the Japanese Indian Consulate at Japan. Now, my lord, now the question arises, is it merely an ministerial act, or they will also apply their mind to arrive at a decision? If they apply their mind to arrive at a decision, then I am entitled to a hearing before that officer also.
Mr. Mojumdar, look at the prayer. I was searching for something to hold on to. There is nothing. It is only that you want to be with your infant daughter in Japan. That's all.
My daughter is in India. My husband is in Japan.
Mother and daughter are together in India, my lord.
I was born in India. I did my schooling in India, everything in India. But suddenly, my lord,
Japan has materialized from nowhere. Mr. Mojumdar, no, I cannot do that.
Very
You,
well.
whatever other orders are necessary.
Then,
on
ma'am, that
fresh
will be a different
proceedings.
test.
Grateful. to you.
Yes, call on the next matter, please.
Item number 19.
Yeah, just make one submission, Your Lordship.
You are appearing
I'm
for?
for respond numbers 2 and 3.
Who is that? Who are those? Who are that?
That's the Director General and the Competition Commission, Your Lordship. I'm only praying, Your Lordship, my counsel is not available.
I can't
today.
understand. Microphone, please.
I'm sorry, Your Lordship, my counsel is not available today, Your Lordship. Can kindly keep it for tomorrow, if it's possible.
Who's your counsel?
Mr. Tilak Bose. He's unfortunately traveling today.
What is the urgency, Mr. Mukherjee?
My lord, I'll tell your lordships, my lord.
Mr. Mukherjee, just in 1 minute, what is the injunction restraining them from, what is this,
Proceeding against me, my lord, I'll tell
13th April?
Yes, my lord, not just that, my lord, the entire proceedings, because there's no order, my lord, under section 26, my lord, of, my lord, the Competition Act. Without an order under section 26, my lord,
So
no.
you have been issued a summons?
Yes, not only summons, my lord, there has been a search and seizure without my name, my lord, being mentioned, my lord, in the information. And my lord, there is no section 26, my lord, order, which is, my lord, a precondition to initiation of investigation.
Very well. Mr. Mukherjee, tomorrow, 13th April.
Grateful, Your Lordship.
Yes, adjournment is prayed for on behalf of counsel appearing for the
Respond number 2 and 3. Your Lordship.
Competition Commission of India. Stop this matter tomorrow.
Grateful. Grateful.
My lord, could it be, my lord, 14th then, my lord? Sorry, my lord, 4th, not 14th, 4th.
Yes, on 4th May 2023 as prayed for.
Grateful.
My lord, my lord, a subsequent event, my lord, has happened, my lord. Maybe, my lord, we put, my lord, certified copies, my lord, to which we had craved reference. My lord, we have, my lord, including, my lord, by way of supplementary affidavit, subject to your lordship's approval, my lord.
Yes,
We've served on them, my lord, sir.
yes, the petitioners, a supplementary affidavit filed on behalf of the petitioners is taken on record. Stop. Have you given a copy to them?
I've given a copy, my lord, and the affidavit of service as well.
Yes, stop. The affidavit of service is kept on record. শোনো 4 তারিখে এটা উপরে করো উঠে যাবো তো Yes.
Grateful.
Yes, call on next matter, please.
Item number 20.
This is my application, my lord. My lord, this involves, sorry. And I believe, my lord, my learned friend had obtained leave from your lordship for moving this application ex parte, my lord. My lord, there's certain urgency, my lord. What has happened, my lord, the petitioner had applied for adoption of a child. Now, my lord, what happens, my lord, when the
Mr. Ray, I have a judgment to dictate in court. Can you come back at 2 o'clock? Or is it not possible?
No, my lord, whenever, because my lord, this is very.
Very well. You proceed. I will dictate it after this. Yes.
I'm very grateful, my lord.
Yes.
30.
And how much time will you take?
Well, I shouldn't take more than 5 minutes because it's ex parte, my lord.
Yes.
I'll point out, my lord, what has happened, my lord. My lord, my lord, she has applied for, my lord, adoption. My lord, there is a procedure laid down in the adoption procedures, my lord, where, my lord, a referral is made by the authority to the prospective parent for accepting or, my lord, accepting a child. Let me put it that way. My lord, that referral had been done, and, my lord, I had chosen a child.
Referral before who?
My lord, the referral is done to the prospective parent.
Yes.
By the authority. They have a pool, my lord. If I should sound a bit crude, my lord, but there is a pool from where, my lord, 3 referrals are done to a prospective parent. You can accept the first referral. If you don't, you accept the second. If you don't, then there's third.
Who makes a referral?
My lord, the referral is made the authority.
Which authority is this?
The respond number 2, my lord. The respond number 2. The Central Adoption Regulatory Authority, my lord.
Yes.
Now, my lord, when this is done, my lord, first, my lord, we have to say that whether we wanted all India or the adoption would be of any child from specific states.
Yes.
In our case, my lord, we had chosen 3 states. One of them was Maharashtra. Now, my lord, we had been given that referral. I'm just cutting the thing short, my lord. We're given the referral. We have accepted that. Now, under the rules, my lord, there is a procedure that the adoption has to be completed within 30 days from me accepting the referral. Now, when I asked them, my lord,
when was the referral made?
My lord, 6th of April, so it's going to end on 6th of May. Now, my lord, when I asked them, they said the authority, the chairperson has resigned. Therefore, I cannot do anything at this moment. And the time goes ticking.
Days, response number
The response number 2.
Yes.
And response number 3, my lord. That's the Maharashtra, that's the state board. Now, my lord, what is happening on 6th of May, if this doesn't happen, then the child gets released into the common pool. So,
show me the rule, please.
yes, my lord. My lord, kindly wait up. And I'll straight away take your lordship to the main regulation, my lord. But kindly takes page 298. Page 298, my lord.
Yes.
And this is the adoption regulations 2022, my lord. Rule 11.
Yes.
And a referral of a child from specialized adoption agency through the designated portal to prospective adoptive parents. But this lays down the rules. My lord, kindly comes to straight away, my lord, kindly comes to 9, my lord. Rule 9 at page 299.
So says from a specialized adoption agency.
My lord, which is the response number 4. This is the specialized agency of the Maharashtra, my lord, state specialized agency.
Yes.
So, my lord, if your lordship kindly comes to rule 11, sub rule 9.
Yes.
The entire process of matching shall be completed within a maximum period of 30 days from the date of reserving the child.
Matching is what?
My lord, matching is, my lord, it matches when once I choose the child, then the committee, my lord, the specialized adoption agency will match it. The child and the prospective parent have to be matched and they will give their sanction. Which your lordship will find, my lord, at.
And who will give the sanction?
My lord, kindly takes rule 11, 5, my lord. The chairperson and another member shall form the quorum of the adoption committee in case of adoption of a specialized adoption agency. The adoption of child case, the committee shall constitute chairperson and 2 other members of the committee. Next is the adoption committee shall scrutinize the requisite documents as stipulated for the prospective adoptive parents listed in Schedule 9 of the regulations. The specialized agency shall organize a meeting of the prospective adoptive parents with the child. At the time of matching, the social worker or specialized adoption agency concerned shall orient the prospective adoptive parents for taking care of the child and also older children for about their rights. The entire process of matching shall be completed within a maximum period of 30 days from the date of reserving the child.
Date of reserving the child means what? What is the date of reserving the child?
My lord, that is when I had accepted the child, my lord. That's 6th of April.
That's 6th April 2023.
Yes, my lord. My lord, kindly comes
so
to
after from the day from 6th April
till 6th
regulations 5, 6, 7 and 8 will have to be done.
Yes, and it has not been complied with on the ground. My lord, kindly now sees the letter, my lord. I think that will, my lord, kindly comes to kindly comes to page 66, my lord.
Yes.
My lord, kindly sees, my lord, this is from, my lord, this is to Kara, my lord, that is response number 2. This is being written by the, my lord, the state reservation agency, my lord. Kindly takes the last, my lord, the bottom, my lord, email. Due to the resignation of the district child protection officer, has your lordship got that, my lord? In Pune, the parents should be given an extension of 15 days as the adoption committee meeting is pending. And then, my lord,
so 30 plus 15.
They are asking for it, but my lord, that is not allowed under the rules.
No, and who is this Aadhaar adoption center? This is a specialized.
My lord, that is the specialized adoption agency, my lord, which I made a party. Response number 4, my lord.
Yes.
So, my lord, they are asking for it, but it is not allowed under the rules.
And now, they are asking who for it?
My lord, response number 2, my lord, the centralized adoption regulation authority.
Yes.
And they are saying, kindly sees 2. Name of child, my lord, has seen that. Name of parents, my lord, has seen that. expiration date is 6th May 2023.
No, very well. So what is the reply?
This is given by them. And R2 has not responded to me in spite of my regular intimation that kindly complete the process.
No, very well. So the adoption agency is saying that the district child protection officer has resigned in
Yes.
Pune. So kindly extend.
But
And what is the reply?
there is no reply.
No, Mr. Ray, the below one is 26, the above is 28.
No response. Another one. Again, it's writing to Kara.
Very well.
That is from the state.
Adoption
There are two parts. There's a state adoption regulating agency. There's a
Yes.
central adoption regulating agency. Under the state, there is a specialized adoption agency which takes care of all these, the matching process.
Yes.
The matching process agency writes to straight away to the central. Central does not reply. Even the state authority
So
writes.
why did you want to move it ex parte?
Because what would happen, the child, I am only saying, till they come, the child should not be put into the common pool. Because by 6th, it will happen. And we are now, nearing that time period.
No, that is a time sensitive issue.
Yes.
But why did you want to move it ex parte?
Because,
Suppose you had given them notice, then what would have happened?
if, we are, may I just put it this way,
Yes, microphone, please.
I'm sorry. But may I just put it this way, the authorities are asking for details of certain documents which are also beyond the provisions. I'm not going into that. But what happens in these kinds of circumstances, the child which is generally chosen, for some reason they try and put it back to the pool, That is why I'm moving it ex parte. I don't think.
So you're saying that they are not interested in
Yes.
going ahead with the adoption?
They are trying to just push it back. And
No, but
go
how
with
would
the-
they be benefited by pushing it back?
there are instances where there are children who are may I just say this, if it goes back to the original pool, then there might be others who are interested in the same child. I'm being very, very crude, in this. Once I've chosen, that is why I'm not asking for anything else, I'm saying that let them come. Only this child should not go back to the common pool. If your lordship is not minded to pass a further order, that yes, this should be completed within in their presence, obviously your lordship can then vacate it and the child will go back to the common pool. But today, I have chosen, I have done nothing wrong. They are only saying, and if your lordship kindly sees the next email, they are saying that they're coordinating with the district women and child development officer. We don't know why. So basically what I wanted, is that they should complete.
Where is your interim prayer protection?
Yes, ma'am.
The interim protection prayers?
Kindly takes prayer J, Sorry, page 25,
Yes. What is carings?
That is the child adoption resource information and guidance system. That's the portal, basically that's the portal. What happens in the portal, first it will go into the common pool, and if I refuse 3 times the referrals, as I said, there is a list of adoptive parents. I will straight away go down to the last number. So again, I'll have to wait till others adopt. Now I have already chosen. So if I don't get, then there's a chance that I'll be put at the bottom of the list. But I'm not asking for that order, I'm only saying that this child may be protected.
So the underlying message is that everybody would be vying for the same child. So therefore, once it's
not
put back,
always.
the child is put back in the pool, there will be others. I don't understand.
Yes, there'll be others. There are referrals made. Referrals are basically chosen by the agency. Let us say there are 3 referrals. 3 children are chosen. First one, if I don't agree, then second, if I don't agree, then third, if I don't agree, then I go to the bottom of the entire list of prospective parents. This is one. Next is what happens once I refuse the referral,
Yes.
the child goes into the common pool. আমি একদিনে সার্ভিস করে চলে আসবো।
The petitioner before the court seeks to adopt a child by following the procedure laid down under the adoption regulations, 2022, which were which came into effect under which was enacted under the power conferred under section 68 within brackets C, choto c, read with section 2 within brackets 3 of the Juvenile Justice brackets Care and Protection of Children close brackets Act, 2015. Stop. Regulation, capital R, Regulation 11 deals with the process of referral, capital R, referral of a child from a specialized adoption agency through the designated portal to prospective adoptive parents. Stop. The petitioner is the prospective adoptive parent, comma, the specialized adoption agency is the respondent number 4, which is based in Pune. And the authorities concerned are, and the authorities referred to in Regulations 11 are respondent numbers 2 and 3, which are the Central Adoption Resource Authority within brackets CARA close brackets and the Maharashtra State Commissioner Women and Child Development, Pune, respectively. Stop. The petitioner next. The petitioner is already at the stage of referral, having chosen a child from the pool of the respondent number 3. Is that correct?
Two, my lord.
Respondent number 2. Stop. Regulation 11 within brackets 9 mandates that the entire process of matching, quotation marks, matching shall be completed within a maximum period of 30 days from the date of reserving the child. Stop. The petitioner reserved the child on 6/4/2023, and hence the exercise under Regulation 11 within brackets 10 is would be required to be completed within 6/5/2023. Stop. The difficulty faced by the petitioner in completing the process of referral and matching are 2 males two males, MAILs, males, written by the Specialized Adoption Agency to
This one, number 2.
respondent number two, respondent number 2, within brackets Kara, close brackets, on 26/4/2023 and again on 28/4/2023, stating that the prospective adoptive parents should be given an extension of 15 days as the district child protection officer in Pune has resigned. Stop. Kara / respondent number 2 has not responded to these mails. Stop. Next, the regulation 11 within brackets 5, comma within brackets 6, regulation 11 within brackets 5 hyphen within brackets 8 sets out the steps to be taken by the adoption committee, capitals, in case of adoption from a child care institution. Stop. The court is informed that none of these steps have been initiated so far. Stop. Is that correct or not correct?
No, my lord, absolutely.
So far.
Because my
Stop.
lord, the chairperson is not there.
So far, since due to the resignation of the chairperson, due to the resignation of the district child protection officer. Stop. Capital survey. Next, the petitioner's apprehension is that the child may be put back into the pool, into the common pool of children for adoption, and the petitioner would be consigned to the to a list, and the petitioner would be required to undertake the exercise all over again from the stage of referral, which the petitioner has already done on 6/4/2023. Stop. Next, before the concerned respondents are heard, comma, this court is satisfied that the petitioner requires an interim protection since the time to complete the exercise would end on 6/5/2023, which is the coming Saturday. Stop. Next, list this matter on when do you want to come back, Mr. Ray?
Well, if your lordship grants me leave to serve by email, I can come back day after, my lord. Or my lord, I'll come back.
List this matter on 8th May 2023. Stop. The petitioner, a learned counsel appearing for the petitioner shall communicate this order on the respondents by tomorrow, i.e. 3rd May 2023. Stop. The respondents shall not release the child on the concerned portal of the what?
of the respondent number 2 being carings.
Of the respondent number 2, namely CARINGS capitals, or in any other common pool meant for adoption until the matter is considered further. Until the respondents are heard or further orders are passed in the matter. Stop.
I am very grateful to your lordship.
ফেরত দিয়ে দাও ওই পাস্ট ওভার ম্যাটারটা ডাকো তো
First one matter, item number 4. The petition.
Sorry, Mr. Banerjee, Mr. Chatterjee, to keep you waiting all this while. I will dictate the order at 2. দুটোর সময় কি আছে? I will dictate the order at
May we come back at 2:30 minutes?
2:30.
But at 2 o'clock, I needn't be here for your lordship to pass the order. My
As long as somebody can
says-
correct the court on facts, that's all. If you have the trust, that's fine. Yes.
2:30, may we come back? Lord?
2:30. Very well, at 2:30.
Lord, then could I just push my luck and ask for 3 o'clock? I have a matter fixed at 2, Lord, it'll take
তিনটের
an hour.
সময় কি আছে? Mr. Banerjee, haggling for entertainment, but 2:45, because I have my part heard matters from 3 o'clock.
Lordship will
Alright.
forgive me if I'm not here. Lord.
I'm sure
Yes, one of us will be.
is ready, completely ready on the facts. Yes, Mr. Chakraborty, which one are you in? 23? দেখি সরো একটু 23 ওটা কি পরেরটা?
Here, I have a point, preliminary point. It's my pleasure to appear before your lordship. The question is, the petitioner has challenged.
Mr. Chakraborty, I am willing to hear you throughout the lunch break.
I shall take justice.
But I am restraining my enthusiasm and asking you to come back at 2. All right? Sorry, there was a meeting, so I got delayed. Ekush.
Item number 21.
But I picked up for the petitioner, my lord.
Yes.
In this matter, my lord, I have challenged, my lord, the lookout circular issued by the
Sorry, I
respondent
can't
bank.
hear you.
I had challenged, my lord, lookout circular issued by the bank against the petitioner, my lord.
Yes.
Now, my lord, your lordship had asked me, my lord, we want to travel, my lord, to Vietnam, my lord. Your lordship had asked us, my lord, to give an undertaking before your lordship, my lord.
Yes.
But we have prepared that undertaking, my lord. We are also giving them a copy, my lord. But
You're appealing for the bank?
My lord, I am from the bank led by Mr. Om Naran Rai.
But page 4, my lord, your lordship will see, my lord, that we had applied for visa, my lord. And page 5, page 6, my lord, is the passport.
No, where have you said that,
Page
where are the tickets?
Page 7, page 7. My lord, on my lord, 13 May 2023, my lord, we are leaving, my lord, for Hanoi, Vietnam.
13th May, it's 12th May.
12th May, 12th May,
Yes.
I stand corrected, my lord. And my lord, thereafter returning, my lord, on my lord, 21st May. Next page, my lord, 21st May, we are returning, my lord, from Ho Chi Minh City, my lord. We are boarding plane there, my lord.
Where are you going?
My lord, Vietnam, my lord, Vietnam.
Ho Chi Minh City.
From Ho Chi Minh City, my lord, we will board.
And you're coming back on 21st May?
21st May, my lord. Now, my lord, I have studied, my lord. I find, my lord, that LOC, my lord, lookout notice, my lord, there are different type of lookout notice are there, my lord. But
Microphone, I can't understand a single word you're saying. Yes.
my lord, there are different type of lookout notice which the authority can issue, my lord. My lord, if, my lord, there is no cognizable offense against me, my lord, then they can only issue a LOC, my lord, which says, my lord, that I cannot be restrained, my lord, from going to foreign, my lord. I have come about this, my lord, in a circular, my lord, in a judgment, my lord. I shall show to your lordship. But it's only said that the originator will be informed, my lord, when I am leaving the country and, my lord, when I am coming back to the country. Same thing has been issued, my lord, against my uncle, my lord. For that reason, my lord, we have been allowed to go foreign, my lord. If your lordship finds, my lord, I have.
No, so you were not stopped.
My lord, we have.
Your uncle was stopped.
My uncle have been stopped, my lord. Even after direct.
So how are you on a similar footing with that of your uncle?
My lord, I was also asphalt director of that same company, my lord, against which, my lord, the LOC has been issued, my lord. But if your lordship sees, my lord, the writ petition, my lord.
No, you were asphalt directors.
Yes, my lord. Or this
company in liquidation.
Company in liquidation, my lord. CIRP has been initiated, my lord. The management has been changed, my lord. And that CIRP proceeding has also been disposed of, my lord. That is also there in writ petition, my lord.
Which paragraph mentions the company?
Yes, my lord. Paragraph 4, my lord, page 4, paragraph 4, my lord, kindly says, my lord. It is pertinent to mention here that the respondent number 4 has filed an application for initiating a corporate insolvency resolution process.
Network Industries Limited?
Yes, my lord. Network Industries Limited, my lord.
And what is the purpose of your visit? Where have you stated that?
My lord, for business, my lord, business purpose, last line, my lord, in that kindly says. My lord, para 5, my lord, I am going to Vietnam for business purpose and nothing else. It's 2, my lord, of my undertaking.
And nothing else? Why do you have to write nothing else? Why? Just say business purpose, that's all.
Yes,
What else do you do in Ho Chi Minh City?
But we are asserting, my lord, that only the purpose is business and nothing else. That's why, my lord, it is written like that. Now, my lord, if your lordship sees, my lord, their circular amount of 2021, my lord, it says, my lord, if.
Very, very well. What else do you want? I will allow you to travel. What else do you want now?
Another thing which I want, my lord, allow them, my lord, to produce before your lordship the original request for issuing LOC, my lord. The reason, my lord, why LOC has been issued against us.
Very well. Now you go to Ho Chi Minh, come back, and then we shall see.
My lord, may I permitted to submit? My lord, the writ petition has suppressed certain fact. The writ petition is a willful defaulter. The writ petition has suppressed certain fact. He is a willful defaulter. He not mentioned in the petition. And his account is declared to be fraud, which was not challenged long back. My lord, we want to file an affidavit to opposition.
Hasn't the Supreme Court said I think 4 weeks back that before you make or declare an account to be fraud, you have to be given a hearing. Isn't there a Supreme Court judgment to that effect?
That I have to read.
Justice Narasimha,
And Chief Justice.
sitting with the Chief Justice of India.
We want to file an affidavit in opposition, my lord.
Let them disclose, my lord, the reason, my lord. My lord, why they have issued a LOC, my lord,
Obviously,
the
obviously.
original request. My lord.
Because this fact is very much relevant to argue on this matter. Mr. Rai is on the matter from the bank.
You want to accompany him to Ho Chi Minh City?
He is welcome, my lord.
No, no, my lord. Absolutely.
No, no.
not.
Yes. The petitioner has filed an undertaking by way of an affidavit as directed by the order dated 27/4/2023. Stop. The petitioner, the affidavit encloses the air tickets to and from Ho Chi Minh City
We are going to Hanoi, my lord, and thereafter we
to Hanoi and return from Ho Chi Minh City on 12th May 2023 and 21st May 2023 respectively. Stop. The reason for travel is stated as business. Stop. The petitioner intends to visit Vietnam for 8 days. Stop. A copy of the passport and the application for visa are also part of the affidavit. Stop. Next. As stated in the last order, comma, the petitioner has not been prevented from traveling outside India, but apprehends that the respondents may interfere with his travel by reason of the petitioner's uncle being prevented from traveling outside. When was he prevented?
my uncle was prevented, my lord, on my lord. Just give him one.
Blank. Stop. The petitioner as well as his uncle were
6/2020.
erstwhile directors of the company which is presently undergoing CIRP under the provisions of the IBC. Stop. When were they prevented?
The 3rd of June 2022.
2022.
22.
June 2022.
June.
Stop. Next, the undertaking the affidavit / undertaking is filed in court and kept with the records. Stop. Next, the petitioner shall be permitted to travel to Vietnam during the period indicated by the air tickets and return to the country on 21st May 2023. Stop. The petitioner shall file an affidavit of compliance after return to India. Stop. List this matter on 7th June 2023. The affidavit of compliance should be filed on the returnable date with an advance copy on the respondents. Stop. Tarpore lekho list this matter on 7th June 2023. Next.
Item number 22.
I beg paper for the writ petitioner. In this matter, my lord, the petitioner has challenged an order, my lord, invoking the bank guarantee on the ground of termination of a contract. Now, my lord, we have challenged on the ground that it's fraudulent because there is no termination of the contract at all. At the time of admission, my lord, the honorable court, my lord, framed that only question is whether there's termination or not. Direction was given on, my lord,
Are
26th
you
of August.
enjoying an interim order?
No, no interim
No.
notice, no. 26th of August 22, direction for affidavit, my lord. On 11th of April, your lordship was kind enough to extend the time for the state, my lord. They have not filed any affidavit. Now, the only issue is, my lord, if there is no termination, then the letter invoking bank guarantee becomes fraudulent, because the ground of the invoking is termination.
So you are protected from the bank, from invocation of the bank guarantee?
No,
No.
it has been invoked, my lord, but since I challenged the order, if your lordship, my lord, I paid for a declaration that the invocation is bad and fraudulent. If your lordship grants that declaration, my lord, then entire action becomes bad. Now, this is my case. They were to, my lord, disclose the termination if at all. My lord,
And directions for affidavits were given when?
26th of August 2022, was direction, and extended by your lordship on 11th of April 2023.
Very well. No one appears for the state respondents. They are the answering respondents. State respondents, stop.
State Rural Development Agency, they are
Affidavits were directed to be filed by an order of a coordinate bench dated 26th August 2022. Stop. Next, learned counsel appearing for the petitioner submits that the respondents are yet to file their affidavits. Affidavit in opposition. Stop. The last order passed by this court on 11th April 2023 indicates, reflects that affidavit in opposition, that extension of time to filing of the affidavit in opposition was allowed upon payment of costs. Stop. It is not clear whether the state respondents have paid this cost, have paid this amount. Stop. Next, list this matter on 4th May 2023, on 8th May 2023. As a last chance to the respondents, stop. The petitioner, learned counsel of the petitioner is requested to communicate this order on the respondents.
Only one submission, my lord. In the server copy of the order dated 11th of April, my lord, there's no reflection of the cost part. Although your lordship directed, it's not
11,
reflected in the
I just saw the order. It
Yes,
says
my lord, but
costs.
the server copy that doesn't reflect.
Server copy. Show it to me. Amar order to the কষ্টটা কোথায় গেল? সার্ভার কপিটা তোমার? কষ্টের পার্টটা তুমি নিয়েছো তো অর্ডারটা? For some strange reason, লেখো. For some strange reason, the portion of the order relating to costs, imposition of costs on the state respondents is not reflected in the server copy of the order dated 11th April 2023. Stop. The portion with regard to the payment of costs is hence reproduced below. Stop. কি করে হয়? একটা থেকে বাদ চলে গেল? Yes, call on the next matter.
Item number 23.
My application. But I seek to challenge, my lord, the vires of the Indian Railway Code as far as, my lord, the release of leave, travel, encashment in favor of the deceased employee's brother. My lord, there was a direction upon me to serve upon the Attorney General's office. My lord, I have served, my lord. I believe my learned friend would be raising a point of maintainability, my lord, as far as the maintainability of the writ petition is concerned.
Yes, Mr. Chakraborty, maintainability.
Yes, only point is, my lord.
Mr. Microphone, please.
Yes. My lord, the
What does the railway code say with regard to leave travel, leave
Lord, it
encashment?
is with regards to the leave travel encashment in favor of the deceased employee.
No, no, what does the railway code say?
Railway code says that in the event, the eldest surviving heir is a brother whose age is above 18 years of old, then in that event, the leave travel will not be released in his favor.
So two conditions,
Yes, 18 and male.
male.
Yes, in case it would have been female, then it would have been released.
So petitioner is also a male before me.
Yes, my lord. So he's applied and it's not been released in his favor. So I've challenged that.
Not the
court.
eldest brother, not the
It is
eldest
the
surviving child.
Only eldest surviving heir as the only brother. The deceased only legal heir is his brother, is her brother.
Yes, Mr. Chakraborty, what
Lord,
is the maintainability point?
yes, my lord, the admittedly they have challenged the constitutional validity of the Rule 549.
Rule 549?
Rule 549.
Yes.
Of the Railway Establishment Code. Now, my lord, Lordship is aware that under the Administrative Tribunals Act 1985.
Yes.
Now, there are so many things, including the definition of service matters.
Yes.
Now, may I hand over, my lord, the book?
Mr. Chakraborty, I don't want to hear this now. You tell me, you come back after what is the urgency?
Well, there's no urgency. my lord.
You come back after the holidays. I don't want to hear this now. What will you argue in any case?
Only thing, my lord, this has to be filed before the Central Administrative Tribunal.
That is what you're saying.
In view of the Constitutional Bench judgment in L. Chandrakumar's case, here it has been categorically stated that in case of all matters, including the constitutional validity, it has to be first thrust out before the Central Administrative Tribunal. And then being aggrieved by any order.
What is the exception to the L. Chandrakumar judgment?
There is, my lord, kindly come to page 100 of the L. Chandrakumar's judgment I am handing over. That has summed up the entire matter, including the exclusion of jurisdiction of the High Court under Section 28. Now, my lord, kindly allow me to place the judgment, page.
Mr. Chakraborty, I don't want to hear you today. You will take a lot of time and
page
how much time do you want?
My lord,
How much time do you want?
just 10 minutes.
10 minutes. You can't complete in 10 minutes.
I shall complete, definitely. If your lordship kindly comes in the list to para 99, which concluding portion of the judgment. Now, towards the middle, kindly find, your lordship may not read the entire para 99. The tribunals, as your lordship got it, tribunals created under Article 323A and 323B of the Constitution are possessed of the competence to test the constitutional validity of statutory provisions and rules. That is the conclusion of the Constitutional Bench judgment. There were all questions relating to the service matters and the constitutional validity are to be placed before the Central Administrative Tribunal. If somebody is aggrieved, he can come up before the division bench either under Article 227 or under Article 226. That is the conclusion of the Constitutional Bench judgment. Now, my lord, in the
And which are the matters which are saved of paragraph 99 of L. Chandrakumar?
my lord, these I didn't wait. Kindly first come to the definition of service matters.
No, paragraph 99 doesn't say service matters.
No, that is
Paragraph 99.
all matters under
Yes.
323A and 323B. It may be land tribunals matter, it may be state administrative tribunals matter, it may be central administrative tribunals matter.
Yes.
The question was before the Constitution Bench whether exclusion of jurisdiction of the High Court.
Mr. Chakraborty, better come some other day. Yes, because I have a judgment to dictate just now. I can't focus on this now. Yes, when do you want to come back? Before the holidays
Next
or after the holidays?
Next Tuesday.
Next Tuesday. Yes. The learned ASG appearing for the railways seeks to take a point of maintainability to the challenge to the VIRES, VIRES of Rule 549A, capital A of Chapter 5 Roman of the Indian Railway Establishment Code, Volume 1. Stop. Prairie. Stop. List this matter on. You don't know that next Tuesday is a holiday.
Oh, no, nice, yes. Tagore's birthday, sorry. Sorry, my lord. Yeah.
When do you want to come back?
Then Thursday, no, Thursday. That is
List this
11th,
matter on 11th May 2023 as paid for.
Great.
এটা বইটা ফেরত দিয়ে দাও আর এটা একটা বই নিয়ে আসবো
Yes, appearance.
Item number 24.
The respondents, my lord, as per your lordship's direction, I have filed the written notes of submission, my lord.
You didn't file it. You sent a copy to my chamber.
No, my lord,
And that is way beyond the time. That's why I haven't looked at it.
my lord, I filed it before 28th, my lord. I
For
gave
28th, where did you file it?
in the, not during the, after court hours, my lord.
But please don't send notes to my chamber. I don't accept it. Or any papers for that matter.
I apologize, my lord. but I-
Always through the court. Because my staff are instructed not to accept any papers from anybody.
My lord,
How can you send it to my
I
chamber?
apologize, my lord. I did not intend that, my lord. I only requested them to keep it in the record. I apologize, matter any, my lord.
Learned counsel appearing for the CLW, respondent CLW, submits that last order to the submits that council has given a short note within the time directed. Stop. List this matter on eighth May 2023 under the heading for judgment.
Deeply obliged, my lord. My lord, I apologize, my lord, for the
That is all
inconvenience
right.
caused,
That is
my
all
lord.
right.
Deeply obliged, my lord.
Lordship.
Item number 25.
That I appear for the petitioner, my lord. This is challenging that lookout circular on the last occasion, my lord, pursuant to my lord's order. That the copy of the office memorandum dated 22nd February 2021 has been handed over.
Yes.
What was being described as a secret document. My lord, I told your lordship, my lord, as far as I was aware, 2021 was really a recompilation of the earlier notifications, my lord, and my lord, I stand by my submission. There is nothing new in this notification. It's a consolidation of the 2010 along with the 2018 guidelines, the 17 and 18, the three guidelines. It's consolidated and made part of one document, and that's it. There is nothing new in that.
Yes.
And my lord, the requirement is there has to be a criminal proceedings. The pro forma is the same. We had attached a blank pro forma with the writ petition. Criminal proceedings detail have to be given. And the only addition is, my lord, in clause L, the numbering has changed. In exceptional cases, you can ask when economic interest of India and strategic interest. That's all. And my lord, only one additional information, additional change that has taken place is in clause J. Earlier LOCs were all for a period of 1 year. Now, my lord, I find LOC open shall remain in force
until and unless a deletion request is received from the originator itself. That's it. Other than that, my lord, there is no change in that. And my lord, so far as on merits, my lord, lordship want, I can start on merits, my lord. This is really after affidavits, but I must indicate to your lordship, my lord, when we were
Mr.
asking.
Chaudhary, that is up to you. If you want to come back after the vacations.
No, my
after
lord,
the
then I
holidays.
would like an interim
Could
order.
travel during the vacation.
No, my lord, I'll indicate, my lord, I must be very candid, my lord, when the writ petition was moved, my lord, that time there were, my lord, a meeting scheduled in China and Thailand, but that is no longer there. Now, my lord, I asked the client that, my lord, because I am aware, my lord, the nature of interim order, lordship usually looks for, my lord, the tickets and, my lord, the destination to be specified with the, my lord, departure date and the return date. But the difficulty in this case is, my lord, he has meetings, my lord, scheduled in the SAARC countries, my lord, Nepal, Sri Lanka, Bangladesh, my lord, these would be, and perhaps it may be one, but he can't be specific that as on this date, I would be traveling here and I would come back. But this much can be done
Okay,
2
but,
days.
if there are meetings, then he must be
No,
knowing
my
the
lord, 2
date.
days before that, he can intimate if lordship, my lord, is pleased to provide this, that 2 days, when as soon as his travel plans are finalized, he'll inform the bank or whichever authority that this is where I am going, I'll come back on this.
No, that has to be in the form of an undertaking to the court. Can't be to the bank.
Usually, my lord, the meetings are at very short intervals. It's within 48 hours or
Then
70.
you come back after in June and we shall see. But can't be to the bank. Yes, Mr. Bhattacharya.
My lord, then, my lord,
I was appearing for, my lord, the Union of India, which includes, my lord, the my lord, the Serious Fraud Investigation Office, my lord, which is investigating, my lord, insofar as, my lord, the involvement of the petitioners are connected. My lord, we have used an affidavit, my lord, wherein we have stated, my lord, the stage of the investigation, and, my lord, there remains, my lord, every apprehension, my lord, which has been, my lord, also stated in the affidavit.
Who is you're not the originator.
My lord, there are two, my lord, LOC lookout circulars, my lord, issued, one at the instance of the bank and the other one at the instance of, my lord, the Serious Fraud Investigation Office, my lord.
Yes. So what is your response if the petitioner travels during the summer break? For
No,
business?
my lord, in our specific case, my lord, that investigation is on, my lord, and there is every apprehension that, my lord, they will not cooperate with the investigation, my lord. We have, my lord, come, my lord, to a particular juncture, my lord, where the involvement of the petitioners, my lord, that cannot be ruled out as of now, my lord. My lord, they were the original promoters, my lord. The entire facts, my lord, they have been narrated, my lord, that has been narrated, my lord, in the affidavit. And so far as, my lord, the aspect of the Bureau of Immigration is concerned, my lord, it is a standard, my lord, affidavit, my lord, that we have filed, indicating, my lord, the scope and extent, and also indicating now that Mr. Chaudhary has the guidelines, my lord. So, my lord, that will suffice. We had just indicated, my lord, the relevant parts of the guidelines.
What about Mr. Guho, the other originator?
An extent, in terms of the, my lord, in terms of the guidelines are concerned, my lord, the guidelines clearly says that if there is any action that is pending against this person, to an extent, if they are the economic offenders, that is the word that has been used, or there is any criminal proceeding that is pending, my lord, it is an admitted fact that they are defaulters, and pursuant to that, these proceedings are pending. So, my lord, in that event, obviously, when we have issued the lookout notice, until that is decided, the bank has objection for this travel. Unless, my lord, otherwise, if the court grants anything.
Mr. Chaudhary, come back in June.
my lord, may I do this, my lord? May I come back next week only to ascertain, my lord, whether, my lord, if I can, if, my lord, something comes up, my lord, I can be specific so far as my date of departure and I can give that undertaking. And otherwise, my lord, the affidavits are complete. I am ready to meet the points. There is no criminal proceedings.
Mr. Chaudhary, that's a different thing that you can argue at the time of
because, my lord, at the adding,
but meetings and all that, there must be evidence
ad
of it.
interim stage, my lord, you would recall, my lord, incorrectly, he submitted that there is CBI proceedings, details whereof are not forthcoming. So, lordship was pleased. Otherwise, I would, my lord, we were making submissions on interim order at that point of time.
No, I did not submit of any CBI proceedings.
Himself, and he said that he later came and he said that there was no CBI. And so far as serious fraud is concerned, we have
ourselves disclosed in the proceedings, my lord. 2 notices were given seeking for some documents, all complied with. And that too, my lord, in 2020 and 2021.
Very well. You come back next week for interim order, but you have to give evidence that there is a meeting.
Yes, my lord. If I can't be specific, my lord, I would also not press for, my lord, because there is no point in just I can't
Yes,
just buy purchase air tickets only for the sake of it.
Yes,
There's no point in.
list this matter. On when do you want to come back, Mr. Chaudhary?
Next Wednesday, my lord, 11th or 10th.
On 11th May 2023. On 10th May 2023. On the for the issue of interim relief to the petitioners. And who are all these petitioners? All of them want to travel.
There are only 2 petitioners, father and son, the suspended directors of the company.
Yes. Next.
Item number 26. Please, Your Lordship.
There was a direction for filing of affidavit in opposition. But we were to file by 12th of April. May I get a extension for a week, Lord?
Order gulo da.
My lord, by an order of 21st March,
তন্ময় কোথায়? তন্ময়?
পরে ফাইলটা হাতে নিয়ে থাক, কোনো চিন্তা আছে, তারপর করিস না।
Yes.
21st March order.
by an order made on 21st March, my lord was pleased to, stay the operation of the, endeavor to, raise the construction.
Yes.
And an affidavits were directed. Now, this was the order, the interim order is still the 19th of May. I have another limb of submissions apart from the one made, on the issue of, the National Green Tribunal hearing the matter and, making directions when, on the day when it heard the matter, it did not have jurisdiction. Because, it was interesting, very interesting point. A 5-judge bench, had heard the matter, which, apparently is contrary to judicial pronouncement, as well as the statutory, requirement, which makes it very clear that the judicial members cannot is to outnumber the expert member. Judicial members has to outnumber the expert members.
So how many expert members were there? 1. And judicial members?
3.
So you're saying 5 judges?
4 judge. I'm sorry, 4.
Yes, very well. That we can consider on the next day. Learned
This
counsel
order
opinion?
was also corrected by a subsequent order, made by your lordship.
3rd April.
3rd April. To a very limited extent, in page 2.
Yes.
But I'm also praying for some extension to file a.
Who are you?
I am for the Union of India. That's one number 2.
Yes. The respondents had been directed by an order dated 21/3/2023 to file their respective affidavits within 3 weeks from the date of the order. Stop. The respondents seek an extension to file the affidavit in opposition. Stop. The respondents now seek an extension of time to file their affidavits in opposition. Stop. THEIR. Yes, how much time do you? Next, affidavit in opposition within 10th May 2023. Reply.
2 weeks.
Within 9th June 2023. List this matter. On 13 June 2023. Stop. The interim order, which is due to expire on 19th May 2023 is extended till 7 July 2023.
Wait, the same order in the next matter.
We will cross the bridge when it comes.
Bombay High Court judgment is very interesting.
Item number 27.
Very well. Yes. Same order.
Same. Great. 26. Great.
Develop.
Item number 28.
Was that matter where I had concluded my submissions when I was for the owner of the vessel. The respondent number 2, AFCONS, was withholding the NOC because it had claims under a second insurance policy. And they didn't have any claim against the first insurance policy in respect of which Mr. Singh's client has already settled my claim in the sum of 8 crores odd, but is not releasing the payment for want of an NOC from AFCONS, my lord.
Yes. Who is to make this?
Of the insurance company. Lord, may I just indicate, my lord, a few
Yes, but you have till about to 5 minutes because I have to dictate a judgment in court.
my lord, your lordship, my lord, kindly come, my lord, to page number 3 of the petition, my lord.
Yes, you're for the insurance company.
Lordship.
Page 3.
Lordship, my lord. My lord, paragraph 8, my lord, is at the bottom.
Yes. Yes.
My lord, subsequently by a letter dated so and so, the petitioner in terms of clause 17 and clause 35 of 55 of the time charter party agreement dated 26th August 19 requested the officials of the respondent number 1 to incorporate respondent number 2 and ONGC limited as co-insured against the insurance policy number so and so.
Your respondent number 1.
Lordship, my lord, Mr. Thakkar's client, my lord, gave his specific instructions to the insurance company, my lord, to include my learned friend's client and ONGC, my lord, as co-insured. My lord, pursuant to his instruction, pursuant to his specific interest, your lordship, my lord, kindly come, my lord, to page number 17 of the policy of this petition, my lord, page 17. My lord, this is the insurance policy, page 17.
Yes.
My lord, in the middle, your lordship will kindly see, my lord, the schedule is given.
Yes.
My lord, schedule, your lordship will kindly see, my lord. Who are the insured, my lord, insureds? My lord, number 1 is Tirupati Vessels, your lordship will kindly see, my lord. The name is written.
Yes.
Tirupati Vessel, my lord, and the name of the vessel is written year of birth. And my lord, thereafter, your lordship will kindly see it continues AFCONS infrastructure. That is respondent number 2. And my lord, ONGC Limited.
Mr. Singh, how much time will you take?
5 to 7 minutes. So 5 minutes, my lord, 5-7 minutes.
Yes. No, because you come back tomorrow then. All right. Because I will dictate a judgment right now.
Lord,
For
instead of
230 hours.
my lord, could it be day after, my lord?
Are you enjoying an order?
No, my lord.
No.
No, my lord.
Tomorrow. Yes. Learned counsel appearing for the respondent number 1 insurance company, who has just started his submissions, will continue tomorrow, i.e. 3rd May 2023. Judgment of
Oh, bless your lordship.
First of all, matter item number 4. And for the state respondent, my lord.
তাড়াতাড়ি করো, তাড়াতাড়ি করো।
My lord,
No further submissions.
will kindly take note of paragraph 7, my lord. I have stated 10 feet.
By the order passed by this court yesterday, i.e. 1st May 2023, it was recorded, the order, the order passed by this court yesterday, i.e. 1st May 2023, recorded that learned counsel appearing for the petitioners intends to argue on the point of the proposed health center blocking a substantial part of the petitioner's entrance, egress and ingress to the petitioner's property. Stop. Counsel had stated, submitted that counsel would not argue any more, not argue on the point of the provisions of the 1971 Act or compliance thereof by the respondents, since the petitioners were already compensated, since the petitioners had already been compensated for the demolition. Stop. Next, the point which hence remains is whether the health center within brackets Sushastho Kendro close brackets sought to be constructed by the state respondents in front of the petitioner's property would can be interfered with on the for the reasons stated on behalf of the petitioners. Stop. According to counsel appearing for the petitioners, the map enclosed with the supplementary affidavit of the petitioners supplementary affidavit of the respondents would show that the proposed construction would block 60 feet of open land in front of the petitioner's house, and only 45 feet would be left free for the ingress and egress of the petitioners. Stop. This position needs to be revisited after the state respondents have handed up a document in court today with a copy to the petitioners, paragraph 7 of which states that the proposed area of the health center may be reduced from 60 to 50 feet. Stop. The paragraph 7, paragraph 7 further states that if the proposed area is reduced to 50 feet, then the free space available to the petitioners for uninterrupted egress and ingress would be 55 feet. Stop. The court is of the view that this court is of the view that the respondents have taken a reasonable stand, and if the proposed construction is indeed reduced to 50 feet, comma.
My lord, will kindly take note of the last two lines of this paragraph.
Then,
We'll also, my lord, spare a 4 feet gap.
then the petitioner's blocked area will only be 50 feet. Stop. The respondents have also undertaken that the health center will be constructed after leaving 4 feet space between from plot number 567, which would also assist in the petitioner's peaceful ingress and egress to plot 567. Stop. Plot 567 is the petitioners, is the plot belonging to the petitioners. Stop. Next. Apart from the reduced construction area of the health center, which the respondents will be directed to follow, comma, the fact that the petitioners, the fact that the petitioner number 2 made a specific admission, the fact that the petitioner number 2 sought for 15 days time to remove the encroachment on 29/3/2023 before the SDO, Jongipur, and also made a specific averment to that effect in the writ petition, persuades this court to hold that the petitioners are not entitled to any further relief, particularly after the petitioners received compensation of rupees, how much did I say?
80,000.
80,000 rupees from the state respondents. Stop. Next, the contention raised on behalf of the petitioners that the state can look at other plots of land which are which have a bigger area coverage and does not come with any objection on the part of the occupiers of the land, loses relevance in light of the view expressed by the court in the above paragraph. Stop. The contention becomes further irrelevant having regard to the fact that the health center has been running on from a rented premises belonging to the petitioner's father, petitioner's father. And the petitioner's father has been enjoying the rent from the premises since 2012. Stop. Next, section 94. Act. বইগুলো দিতে বলো। Section 94, within brackets III, within brackets choto a, of the West Bengal Panchayat Act, 1973, the theke capital. provides that members of the House of the People, capitals, and the Legislative Assembly of the state elected from a constituency shall be part of the Panchayat Samiti of the concerned block, capital B. Stop. The other sections of the 1973 Act, including sections 110, 111 and 119, indicate the constitution of the Panchayat Samiti. Stop. Section 110 and 111 empowers the state government to place, authorizes the state government to place any property under the Panchayat Samiti including any road vested in the state government and further that the Panchayat Samiti may transfer to the state government or to the Zilla Parishad any road or part of a road which is under the control or management of the Samiti to the state government on such terms and conditions as may be agreed upon. Stop. On a conjoint, on consideration of these provisions, comma, the notice referred to in the order passed by this court on 24/20/2023 asking the calling upon the political functionaries of the locality to be present during the act of demolition. Dilutes the finding of malice in law on the part of the respondents. Stop. Malice in law, capitals, quotation marks, on the part of the respondents. Stop. The findings recorded in the said order to the extent of the respondents subverting the provisions, the procedure under the 1971 Act. What is the full form? Public premises? Public premises within brackets. The public premises within brackets eviction of unauthorized occupants, close brackets Act, 1971 are modified to that extent. Stop. Next. Nothing further remains to be decided in the writ petition. Stop. The petitioners have been compensated and have no other and can have no other difficulties for the proposed construction of the health center in plot number 852. Stop. WPA 9482 of 2020. The restriction, the injunction on the state respondents is accordingly vacated, WPA 9482 of 2023 is disposed of in terms of the above.
My lord, may I have a lordship's leave to make a submission in respect of the 4 feet space in between the land.
No further submissions.
My lord.
Yes.
This
Not after dictating.
for maintenance, it should not be 4 feet.
Call on the next one.
This act is of 62, my lord. He has recorded 71. Lastly, my lord.
No,
Unauthorized.
ওটা 1971 না 1962 দেখো কি একটা দিল আমাকে 1962 একটা দেখ just give him the full form, please.
And my lord, the criminal proceeding initiated.
Yes,
should
call
not
on
be
the next matter,
proceeded,
please.
my lord.
Call on the part-heard matters, please.
I'm extremely grateful. Part-heard matter item number 227.
Distinguishing, my lord, my learned friend's judgments.
Yes.
My lord, on the last day, my lord, I had also shown, my lord, that Bombay High Court judgment, my lord, which says, my lord, that so far as regulation of, my lord, rates of private hospitals are concerned, even the state does not have that power. And that,
Yes.
my lord, picked up-
Which one was
my
that?
lord, kindly have a look at, my lord, that. Because my learned friends, my lord, contention that, my lord, the state will, my lord, frame the,
No, the Bombay High Court is which one?
my lord, that's, my lord, Hospitals Association. That's 2020 SCC online, Bombay 1866.
No, which page of the
Oh, yes, my lord,
of the index? It's not page.
no, my lord, it was not, my lord,
Not part
I
of the-
separately, my lord, gave it, my lord, he had not, my lord,
Yes, yes,
my
yes.
learned friend had not, my lord,
Yes.
relied upon it, my lord. In fact, I had said that he should have, my lord, also, my lord, disclosed it, my lord,
Yes.
and my lord, I also showed, my lord, that
The
division.
division bench,
Yes,
yes.
yes. Because they are, 20.
Yes. And what was the
Well,
point, Mr. Banerjee?
My lord, will recall, my lord, 38-4.
No, in the for the Bombay High Court judgment.
Bombay High Court, my lord, saying, my lord, the state, my lord, had framed, in fact, my lord, regulations here, which, my lord, determined, my lord, rates for both COVID and non-COVID. So, my lord, they looked into the fact, my lord, whether, my lord, the state had, my lord, the jurisdiction or, my lord, the authority, my lord, to regulate non-COVID patients, and they said no, because, my lord, that does not even come, my lord, within the state list at all.
Yes.
If, my lord, looks at, my lord,
Yes, I remember.
yes. Paragraph 17 and 18, my lord, was where the ones, my lord. My lord had looked at it, my lord, on the
Yes.
last occasion. 17, if just, my lord, for a quick, my lord, reference back, my lord, paragraph 17, my lord, see the first question. is whether entry 6 in list 2 state list of schedule 8 under the constitution dealing with subject public health and sanitation hospital disciplines empowers the state legislature to enact any law capping or regulating the rates chargeable by the private hospitals to non-COVID patients.
Yes.
Then none of the should I have seen that Malad wants me to. So then Malad just answers the question.
The last, the portion in bold.
Yes, yes.
18.
Absolutely.
Yes.
Absolutely. And Malad, this I showed Malad went up to the Honorable Supreme Court. That order Malad had also given.
Yes.
And Malad, the special leave petition Malad was also Malad. That we had given Malad. We are not at the act. High Court.
Yes, yes.
And Malad, the SLP order, Malad, this is the SLP order.
Yes, I remember.
Yes.
Yes.
And Malad, what I showed Malad the division bench order of our courts, which Malad, I think Malad's office have just Malad given.
Saying that the Advocate General.
Yes. Learned senior, yes.
Yes.
The second paragraph, very important, Malad, learned senior standing counsel for the state is informed, though in pursuance to section 38 of the West Bengal Clinical Establishment Sanstha Commission has made the recommendation to the state, but in the meanwhile, guidelines issued by the state of Maharashtra having similar effect was challenged before the Nagpur bench, struck down by the High Court, holding the state did not have any such power against such judgment in Nagpur. SLP was also dismissed. Is permanent based on records. So now I am showing Malad that the argument
And
that Malad,
the 17th March order says that state will file an affidavit.
yes. The 13th, 17 March 2023, Malad, I don't know Malad what has, I think we had copies of that. Malad, they have not.
Yes, just that the learned Advocate General said that sought 3 weeks time.
Yes. So Malad, what I'm on Malad, just Malad to round up Malad that argument which I was making, I'm saying that Malad, this issue Malad has already been considered Malad by Malad the division bench Malad of the Bombay High Court, saying that the state also doesn't have the power under the state list to Malad regulate the rates for private hospitals.
Yes.
For non-COVID patients. So if that is the situation and the state of West Bengal has recognized that present state of law, and I said that though the state commission has recommended, but we have not yet done anything about it. So Malad, it's a serious issue, Malad, which really Malad, because now Malad, what has happened? The state commission itself, Malad, is capping the rates. That is the subject matter challenge in this writ petition.
Yes.
We said, Malad, that our main contention, which Malad will obviously Malad remember, Malad, that 38(4) says that only it can be done by way of regulations, but the state commission, though there being no regulation itself, was now issuing rates, saying this would be the rate for this procedure, this would be the rate for this other procedure.
And why was Mr. Sen saying that the state should be made a party and asked?
On the last occasion, Malad, he said that if the state says that they're not going to frame the regulation, then that is the end of the matter. To that, Malad, I say state is not involved here. We have challenged the power of the commission, which is any event, a body, Malad, which is a delegated body, Malad, from the state. Because that body, Malad, has the commission is established, Malad, under the Clinical Establishments Act.
Yes.
And in this context, Malad, my learned friends, Malad, cases, Malad, he had shown Malad cases which said, according to him, that Malad, the state, according to him, Malad, the commission can frame rules or regulations like this or can issue these directions because the state has not framed regulations.
Yes.
That is, Malad, his argument. And I am saying, Malad, no, you don't have the power. If it is through 38(4), then it can only be through 38(4). But now, Malad, it seems that is also, Malad, under Malad, serious Malad issue. Whether 38(4) enables the state also, Malad, to legislate or not, that is, Malad, also Malad, now in question by reason of the Bombay High Court decision. Now, Malad, if Malad takes Malad this bunch of Malad judgments, Malad, I distinguish Malad lot of them. I'll just Malad try and quickly Malad go through the other ones to show Malad that these are not also not applicable, Malad, so far as we are concerned. The state commission cannot Malad have power, Malad, to give Malad this direction instead of Malad the regulations. Malad sees Malad, since Malad it's been Malad the heading, if Malad sees the heading,
yes.
Malad first is Malad West Bengal Clinical Establishment Registration Act, Social Welfare. Malad, this is not relevant because Malad this is only upheld Malad the Act itself, my lord. Then, my lord, a statute cannot and does not provide. That's B. His section B, my lord, cannot and does not provide for all contingencies. My lord, I had distinguished this judgment by saying, my lord, they are not relevant. The Narayan Prasad Lohia, Nikunj Kumar Lohia, because this was under the Arbitration Act. Then, my lord, next.
No, this, you're saying it's under the Arbitration Act.
It's under the Arbitration Act, my lord, where, my lord, there was a question of, my lord, two arbitrators, whether, my lord, they can pass an award or not, whether, my lord, it was a non-derogable provision or, my lord, a derogable provision. That was, my lord,
Yes.
really the issue. Then, my lord, sees B, his B, that is B, then C. When powers and privileges, that's the heading, when powers and privileges are granted by statute, then everything indispensable to their exercise, indispensable to their exercise or enjoyment is also impliedly granted. Now, my lord, here, my lord, I am, my lord, shown these judgments, and, my lord, the points, my lord, which we make was that, my lord, where, my lord, there's a specific, my lord, power given, then, my lord, no question of, my lord, exercising, my lord, any general power. Because, my lord, all of these judgments, my lord, including, my lord, the first one, my lord, I had shown, my lord, 56 Hyderabad.
Yes.
My lord, will recall, my lord, whether, my lord, the evacuee, it gave a very general description. My lord, evacuee property, what was the meaning of the evacuee property, and whether, my lord, if my lord, a stranger held the property along with it, whether, my lord, they had the power to take it over or not. That was, my lord, really the issue. So, my lord, this broad proposition which my learned friend gives, my lord, saying when powers and privileges are granted by statute, everything indispensable to the exercise or enjoyment is also impliedly granted. My lord, my one sentence, my lord, distinction is that if there is a specific power, then, my lord, this general proposition does not apply. Because all these cases, my lord, there was no specific power. It's a question of, my lord, interpretation of the statute to, my lord, say that if it is general, then to carry out that general purpose, you need that power.
Yes.
Lord, like for instance,
Lord H, Lord, although it's in the compilation, Lord, I did not, Lord, place it for you.
H.
It's there in the compilation, Lord, I had not placed it.
As in heading H.
Heading H.
Yes,
did
when Mr. Banerjee comes to it, you can remind. Yes.
See, my lord, if I just pick up, my lord, any of these cases, if, my lord, looks at, my lord, for instance, my lord, item 2, ITO versus MK Muhammad Kunhi. No, George Shaver, item 2 also. My lord, that's at page
47.
47. Item 2, sir. If, my lord, looks at, my lord, this Malad, if Malad looks at page 48, Malad, this is Malad, the question of Malad, whether the appellate authority had, Malad will recall, Malad had shown the judgment.
Yes.
Appellate authority, Malad, had the power, Malad, to pass, Malad, stay or not. And the logic of Malad, the court, or Malad, the reasoning of the court was that Malad, since Malad, it had Malad, general power of to regulate its own procedure, and Malad, since the tribunal, Malad, had the power, appellate tribunal, Malad, should also have the power. If Malad looks at 48, they set out, Malad, section 255. Subject to the provisions of this paragraph 4. Subject to the provisions of the Act, the appellate tribunal shall have power to regulate its own procedure and procedure of benches, therefore, thereof in all matters arising out of the exercise of its power or of the discharge of its functions, including places at which the benches shall hold their sitting. Then appellate tribunal shall, for the purpose of discharging its function, have all the powers which are vested in the referred to in section 131, any proceeding where the appellate tribunal shall be deemed to be a judicial proceeding within the meaning of section 193, 228. So this was only the power given. Then, Malad, paragraph 6, there can be no manner of doubt that by the provisions of the Act or the Income Tax Appellate Tribunal rules, 1963, powers have not been expressly conferred upon the appellate tribunal to stay proceedings relating to the recovery of penalty or tax due from an SSE. So, Malad, this is what they find. Then kindly see, Malad, paragraph 13. at page 51. Section 255(5) of the Act does empower the appellate tribunal to regulate its own procedure, but it is very doubtful that if the power of stay can be spelled out from the provisions. In our opinion, the appellate tribunal must be held to have the power to grant stay as incidental or ancillary to its appellate functions, jurisdiction. This is particularly so when Section 220, subsection 6 deals expressly with a situation when an appeal is pending before the appellate assistant commissioner, but the Act is silent in that behalf, and the Act is silent in that behalf. When an appeal is pending before the appellate tribunal, it could well be said that when Section 254 confers appellate jurisdiction, it impliedly grants the power of doing all such acts or employing such means as are essentially necessary to its execution, and that the statutory power carries with it the duty in proper cases to make such orders for staying proceedings as will prevent the appeal, if successful, from being rendered nugatory. So, my lord, this is not, my lord, a power, my lord, which can be read into the commission to then say, my lord, that we will give directions for regulating the rates of, my lord, private hospitals. This is, my lord, not akin to that. Then, my lord, the next series of, my lord, my lord, next judgment, my lord, page 52, my lord, I'll just show, my lord, paragraph, my lord, 22 of that, my lord, I'll take correct. Lord, in this, my lord, is also under that same group, and paragraph 22 is exactly, my lord, what we are saying. My lord, there were two rules, my lord, this related to, my lord, imposition of, my lord, excise for, my lord, cigarettes, rule 10 and rule 10A. And, my lord, what it says, rules 10 and 10A place side by side do raise difficulties in interpretation. Rule 10 seems to be so widely worded so as to cover any inadvertence, error, collusion, or misconstruction on the part of an officer, as well as any misstatement as to the quantity, description, or value of such goods on the part of the owner as cause of short levy. Then Rule 10A would appear to convert any deficiency in duty if the duty has for any reason been short levied, except that it would be outside the purview of Rule 10A if its collection is expressly provided for by any rule. Then, my lord, sees both the rules as they stood at the relevant time dealt with collection and not with assessment. They have to be harmonized. Then, my lord, in NB Sanjana's case, this could harmonize them by indicating that Rule 10A, which is residuary in character, now kindly see, my lord, would be inapplicable if a case fell within a specified category of cases mentioned in Rule 10. My lord, same as what, my lord, we have understood, my lord, we have seen in Civil Procedure Code also. My lord, your 151, my lord, is only a power which can be exercised when there's no specific provision. Well, Section 151 residuary power, my lord, as we, my lord, have seen that 151 is resorted to when there's no specific power in the code, my lord, to deal with it. If there is a specific power, no question, my lord, then falling back, my lord, on the general rule. Now, my lord, the next, so this two, I think, my lord, are if I say, my lord, a selection of, my lord, these all cases, my lord. So the next, my lord, is D. If rules are silent, kindly see, my lord, the heading, my learned friend, my lord, heading itself, my lord, is in a way, my lord, self-defeating. He says if rules are silent on any particular point, the authority can fill up the gaps and supplement the rules and issue instruction not inconsistent with the rules already framed.
So you're saying, Mr. Banerjee, that this would have held good if 38(4) did not authorize the state?
Yes. Absolutely. That's, my lord, the absolute. If 38(4) was not there, then yes. Then, my lord, whether it came under 38(1) to generally regulate or not would have, my lord, been the issue. And, my lord, all these cases would have been relevant. But if 38(4) is there, which specifically says rates, then no question. And through regulations, then no question of the commission, then, my lord, coming and saying that we will now issue directions which will be akin to those regulations. And this, my lord, entire, my lord, my lord, the Santram case, my lord, that's at page 93. And in fact, my lord, all these cases, my lord, will find, and I had also made a submission, my lord, from serial 1, my lord, D1 onwards, my lord, that except, my lord, for 2 of them, I'll show that, my lord, all these cases, my lord, are mostly, my lord, dealing with, my lord, service conditions. All these are service conditions. And, my lord, there's also a proposition, which, my lord, is, my lord, there, my lord, in the
No, you had said something
Yes.
last time about there being an essential difference between service conditions and a matter of this nature.
Absolutely. That was, my lord, I was just going to, I'm so grateful, my lord. I had said, my lord, the proposition which, my lord,
But I've forgotten what you had said.
my lord, I'll just, my lord, I'm so grateful, my lord, that, my lord, I had said that, my lord, when it comes, and that's, my lord, quoting, my lord, from one of the judgments, my lord, T. Kaji, saying, my lord, that when it comes to matters of dealing with service matters or, my lord, internal matters, then reading implied power is still permissible. But when it comes to affecting the rights of others, then, my lord, it has to be backed, my lord, by law.
Others as in?
My lord, other, my lord, people who are not within the organ
Non-service.
in that sense, my lord, beyond, my lord, service conditions, my lord, when it affects or impinges the rights of, my lord, citizens. Because here, my lord, of course, my lord, when, my lord, we come to private hospitals, my lord, if their rates are regulated, then it can't be, my lord, a commission sitting and, my lord, saying, I have implied power to regulate your rates which you charge. This is not akin to, my lord, the judgments relied upon in service condition where, my lord, they say in some judgments, my lord, it was a long-standing practice, my lord, in police services, my lord, with a merit and seniority. When merit is equal, then they'll look into seniority. But if you have merit, so that was challenged, saying that where are the rules? So then they said implied power, and that is understandable. And this proposition of law, my lord, which I said, my lord, is actually, my lord, very really, my lord, put, my lord, at page, my lord, looks at 173 of, my lord, this bunch, my lord, and discussing, my lord, the case of T. Kaji, my lord, which my lord, if my lord looks at just, I'm sorry, my lord, I'm just troubling, my lord, from page 172, paragraph 21.
Yes.
So long as staff regulations are not framed under 58(1), it is open to the central board to issue administrative circulars regulating the service conditions of the staff in exercise of powers conferred by section 7(2) of the Act. In T. Kaji versus U. Jormanik, CM, a district council was constituted under the 6th schedule to the constitution for the United Khasi and Jointia Hills in the area of Assam. Rules in the 6th schedule empowered the district council to make laws with respect to various matters regarding administration of the district, including appointment of or succession of chiefs and headmen. No law was, however, made regulating such appointments. Even so, it was held by this court that the district council had the power to appoint or remove administrative personnel under the general powers of administration vested in it by the 6th schedule. Delivering the leading judgment of the bench, then Justice Wanchu said that where executive power impinges upon the rights of citizens, it will have to be backed by an appropriate law. But where executive power is concerned only with the personnel of the administration, it is not necessary that there must be laws, rules, or regulations governing the appointment of those who could carry on the administration under the control of the district council.
So you want to read in private hospitals here also?
Malad, with Malad, the rights of citizens. Because Malad, they are Malad, they are not Malad constituents Malad of the commission in that sense. So Malad, if you have to Malad regulate private hospitals, there has to be law. And now Malad, kindly see Malad, Bombay in fact has held, the state also doesn't have the power.
Yes.
Even state doesn't have the power, Malad, no legislative competence so far as state is also concerned. So Malad, the commission can't come and say that, no, I want to now have this. But I'm just showing Malad all his judgments, Malad, on the principles that Malad, they're mostly service matters. And there are few Malad, just two I need to distinguish because I thought
You're saying that these were instances where that gap was required to be filled.
Absolutely.
Yes.
Correct. Malad, administratively, you were required to, you are the authority. Administratively, the authority needs to fill up this gap so as to regulate or put into effect the implementation of something. Here, Malad, that is not the case.
Yes.
Here, that is not the case. Now, Malad,
Mr. Banerjee, how much more time will you take? I have another matter before I go on to the original side.
Well, I was hoping to finish it well, another 15, no, well, 10, 15 minutes. Well, I'll try and rush because well, I've been we both been troubling my lord for quite some time. So I just
No, just quickly finish the cases then. Then I will, because I have another matter, then I go to the original side.
well, I'll just
Yes.
I think that's my argument has I think is that's my argument is I mean
Yes.
I also have several advisors coming in as to kindly come
Advising you to finish today or the next day?
no advisors to put through to my lord, and then there's a problem. I want to finish kindly come to then D advisories D then kindly see E is very important again and my learned friend is very he is very good because he's also said the law. It says when there are no statutory rules in force.
Yes.
Again, says first one was silent. We are not silent when there are no statutory rules in force on a particular subject, or even if there are statutory rules but they're silent on the said subject, it is competent for the government. Then again, another distinction. It is competent for the government to fill in the lacuna in the statutory rules by an executive order stroke administrative instruction. Again, my learned friend is again not the government, because we have restricted ourselves to the question of. So the next distinction I submit is there most of these cases again the government was issuing the advisories, all the directions. Now one judgment I just want to show. The page 158. In all these cases, 1, 2, 3, 4, which sees under E, there was silence with regard to the rules. Therefore, it was considered that it could be given. Now, the next lot, F. F is I just want to show two judgments. F, it says the heading is in the intervening period between the formation of the statutory authority and the framing of the regulations, the commission is empowered to do all that is necessary and essential for the efficient performance of its duties. This will find the judgments at page 158. And kindly see what is the most important. Again, this is a service condition, and sees this is Road Transport Corporation appointing its own employees, and then kindly see paragraph page 159. 45 says corporation may, with the previous sanction of the state government, make regulation not inconsistent with act and rules made thereunder for the administration of the affairs of the corporation. This is what was there. Then kindly see paragraph 3.
Yes.
In Dundee Herbert Trustee Such, Viscount Holden, Lord Chancellor, said the answer to the question whether a corporation created by statute as a particular power depends exclusively on whether the power has been expressly given to it by the statute regulating it or can be implied from the language used. Question is simply one of construction of language and not a presumption. Bearing in mind the statement of law, let us consider whether the appellant has the power to appoint officers and servants and to lay down their conditions of service in the absence of regulations framed under section 45 2C of the Road Transport Corporation Act. The appellant is an autonomous corporation incorporated under the Act for the purpose of operating road transport service in the state and extended areas. For the proper, this is the reasoning, for the proper discharge of its functions, it is necessary for the corporation to appoint officers and servants. Section 142 clearly confers upon the corporation incidental power to appoint its officers and servants as it considers necessary for the efficient performance of its functions. Section 19(1)(c) empowers it to provide for its employees suitable condition service. 14(3) provides for the condition service. Then my lord, kindly see my lord, last 4 lines, last 5 lines. But until such regulations are framed or directions are given, the corporation may appoint such officers or servants as may be necessary for the efficient performance of its duties on such terms and conditions as it thinks fit. There is necessarily a time lag between the formation of the corporation and the framing of regulation of 45(2)(c). During the intervening period, corporation must carry on the administration of its affairs with the help of officers and servants. In the absence of clear words, difficult to impute to legislation.
So what is the point you're trying to
Well,
make?
the point is, my lord, that this was, my lord, a power read into the act only for the purpose of, my lord, discharging the functions of the corporation itself, and, my lord, for its employees. And, my lord, it also says for that, so that it can carry on the administration of its affairs with the help of officers and servants. My lord, here, my lord, there is no such necessity for, my lord, the court, my lord, to imply a power which will allow, my lord, the commission to then, my lord, issue directions, my lord, to third parties, my lord, for the purpose of, my lord, regulating. So the context in which, my lord, the court read into the power was, my lord, totally different. It is, my lord, only for the purpose of discharging all of that functions of the commission. So, my lord, this is only, my lord, one of the exceptions which I found.
Exceptions to?
My lord, on the question of, my lord, whether, my lord, the interpretation of the rules, because all of them, my lord, were on the silent. If specific, all of them are, my lord, silent. So, my lord, there was no powers given. Here, my lord, it only case, my lord, which, my lord, read into the power of the corporation to appoint its own employees or to regulate its officers only to discharge its functions.
So you're saying that the corporation did not have the power?
Corporation, my lord, it was supposed to be, my lord, with the previous sanction of the state government, make regulations.
Very.
And, my lord, it had all the other powers, my lord, with regard to, my lord, appointing its persons, appointing its officers, power to appoint officers, provide for conditions. All these powers were there.
Yes.
So, my lord, this power only was read into, my lord, for the purpose of, my lord, making the corporation operational, so to say. Then, my lord, straight away, my lord, comes to, my lord, one judgment which I don't know why, my lord, my learned friend, my lord, actually showed it, because, my lord, that is in my favor, and that is, my lord, supports what, my lord, we have been urging. Again,
You're on which heading?
My lord, now, my lord, E, I have F I have shown. Then, my lord, G. It says when regulations have not yet been framed on a particular subject by the statutory authority in exercise powers conferred on the statute, is open to the statute to issue administrative instruction regular the subject on which regulations required to be framed. Then, my lord, he relies on, my lord, a series of 5 judgments there. But kindly look at, my lord, kindly see serial number 3, which is at page 189. I'm sorry, my lord, just actually I'm time up. Do to 182 to distinguish. My lord, I'm sorry, my lord, I don't know whether, my lord, I'm running out of time, but, my lord, I need to, my lord, distinguish, my lord, page 182, that is, my lord, item 2. Item 2 and item 3, my lord, if I can show. Now, the UP State Electricity Board, my lord, this is not, my lord, a service matter. That is why, my lord, I thought, my lord, I must distinguish it.
Mr. Banerjee, just give me the paragraphs
Yes.
and the point, that's all.
My lord, the point is this, my lord.
Sorry, this is page?
My lord, page 182.
182. Yes.
My lord, here, try and, my lord, summarize it, my lord, as, my lord, there was a power given, my lord, to the UP State Electricity Board, my lord, to have, my lord, regulations for, my lord, fixing of tariff.
Yes.
So the regulations were not there, but, my lord, they fixed the tariff. It was challenged, my lord, by Missouri. My lord, the court interpreted. My lord, interpreted to say that the section 46 actually gave power to the board to fix the tariff. And it could not be inconsistent with anything if regulations came also. And that is how the interpretation happened. Kindly, I'm sorry, just kindly look at page 185. Paragraph 6. Well, let's see, this is the section. Material part of section 46 of the Act reads thus.
Yes, Mr. Banerjee, I will read it. Yes. And the court came to the conclusion that the board actually had the power.
Yes, that is held in paragraph 7 at the next page, 186.
Yes.
At the top, will find, but section 46(1) of the Act does not say that no grid tariff can be fixed with until such regulation made. It only provides that the grid tariff shall be in accordance with any regulation made in this way. That means if there were any regulations, the grid tariff should be fixed in accordance with such regulation and nothing more. We are of the view framing of regulation under section 79H of the Act cannot be a condition precedent for fixing the grid tariff. So the language of the section, on the basis of the language of the section, they said no, board had the power. And if looks at the language, that is also the language, but not in our case. And one, actually, now we set up just item 3, which is in our favor. This is 189. V. Bala Subramaniam.
Yes.
My learned friend relied on paragraphs 4 and 11, but I'm sorry, 11 was really a submission which was being made. It is not the finding of the court. And paragraph 17 is what is held at page 204. Just kindly mark that paragraph. I think that would be the at page 204, paragraph 17.
Yes.
Regulation 28D of the regulations, that is at para 8 that is set out.
Yes, so a concurrence had been taken from the state government.
That is what the rule said. Then if turns over the page, they
Yes,
said that is not.
that's what I'm looking at. 205.
Yes,
that,
yes, absolutely. So it said that having the imputed promotion, therefore liable to be set as and the board should be.
Yes, so the board had to
Yes.
go according to the
Yes,
concurrence.
yes.
Yes. Mr. Banerjee, last 2 minutes, please.
Then kindly come to the heading again back to the heading
H, Mr. Sen has given up.
Yes, H there is nothing in H in any event I don't know how it would have helped
Yes, what is the last one?
last one is then I, then Roman, sorry, 2.
Yes.
It is same as 5. Here kindly make a note in 250 to 267, paragraph 22 and 32.
Paragraphs?
22 and 30. Sorry.
Yes.
In fact, it says where specific provisions there are no general provisions to be looked at. And section just to round up 38(4), it is very clear. It doesn't empower the commission on its own to make rules and then regulations will follow. It says commission shall make regulation with regard to fixing of rates or charges for indoor patient department and outdoor patient department treatment, including diagnosis also to ensure. And regulation, my lord, is only, my lord, with the
So petitioner is Apollo or somebody else also?
no, my
Only
lord,
Apollo.
Apollo multi-speciality hospitals.
They don't want to be fettered by these rates of the clinical establishment authority.
Yes, my lord, that's right. That's right, my lord. Because, my lord, I've not, my lord, in fact, gone into the question, my lord, that how did they fix it? Because that is also arbitrary. I've not gone into it only because, my lord, I showed, my lord, that they don't have the power itself. Because state commission, my lord, they can't fix it. And now, my lord, as, my lord, from the judgments, it appears even the state can't fix, my lord, these rates because it is not, my lord, within the state list.
And according to you, they were not also fixing any problem in the process.
My lord, I don't think, my lord, that is, my lord, if, my lord, there are question of high rates, people will not go to it. They'll go to a different hospital. They have a choice. They have a choice because, my lord, hospitals also, my lord, has to sustain. They have put in, my lord, money to, my lord, try and, my lord, sustain themselves. My lord, it's a, apart from, my lord, of course, my lord, the hospitality, my lord, is, my lord, is question there. But, my lord, the question of, my lord, putting in an investment and all that, my lord, they will not be aware, my lord, not in a position also, my lord, to fix the rates, to know how much investment has gone in. Every hospital, my lord, can't have, my lord, the same,
yes,
which is exactly what they're doing. A smaller hospital, my lord, obviously, my lord, will have a
They're
less.
fixing rates for all private hospitals.
Yes.
Clinical establishments which are
Yes. Because, my lord, the government hospitals are different. Government hospital, my lord, are different. My lord, that's a different, my lord.
They don't require rates to be fixed. That's what you're saying.
No, my lord, they have anyway, my lord, rates, my lord, which are there. But this, my lord, my lord, my submission is, my lord, apart from the competence, my lord, of whether, my lord, they have the power or not, is also a question of, my lord, having, my lord, the basis also has to be there. It can't be, my lord, state commission says very well, I'm fixing it at this amount of money.
Very well.
My lord, those are submissions, my lord. I'm extremely grateful, my lord.
Yes.
Lord, kindly give me one day to deal with the Bombay judgment, Lord.
Deal with
The Bombay judgment which was cited, Lord. One day, Lord.
On that day, Mr. Sen and Mr. Banerjee, you file your notes also.
Yes.
Very
All
good.
right.
We'll do that.
So then
Yes.
please give us a fortnight's time.
No,
Lord.
my lord, I'm, my lord, this, my lord, has, my lord, Mr. Sen, my lord, in fact, has taken, my lord, several days, my lord.
Fortnight takes us into the holidays.
No, 15th.
No.
15th.
Notes file
No.
Of course. You've given us notes with
No,
judgment.
while I was submitting, I was referring to my pages, which for convenience I do.
Well, they've given us notes, well, brief notes of submission.
When I was making submissions, I had my
Mr. Sen, what more do you want to file after these notes? It's
that
huge.
is not my Lord, it was to help me. But when I was referring to it, Lord,
Unless you wanted to simplify the headings, that you can do. That you can do.
Lord, please give me some time, Lord. I've not taken time, Lord. I've tried
No, what other note do you want to file?
Lord, I want to put the entire argument, Lord, in a proper systematic form and also deal with what Mr. Banerjee has said. Those were notes for my own, Lord, use while I was arguing. Since I had it with me, Lord, your Lordship was inquiring what I was looking into. I gave a copy to your Lordship.
Well,
I
was on reply because I'm for the petitioner. Well, I've only shown one judgment, my lord, which in all fairness, my lord, my learned friend should have really come and also shown that.
I'm not raising any issue with
Very
that.
well. You file your notes, whatever you want to file. When do I keep the matter? Tell me how much time you want.
15th, Lord. Please keep it on 15th, Lord.
Learned counsel appearing.
16th, I think Tuesday or
Learned counsel appearing for the petitioners has concluded his submissions. Stop. Petitioner Akjon Bodhan. List this matter on 16th May, as prayed for, for learned counsel appearing for the parties to file their respective notes of arguments.
And Lordship will hear me for 5-6 minutes on the Bombay judgment, Lord. I'll deal with that.
You don't want to include it in your note?
I will, of course, certainly include it in my note.
Very well. Yes. Call on the next matter, please.
Item number 228.
Lord, I am for the respondent.
Lord.
Yes.
Well, I have shown your lordship, my lord, that after my lord, the confirmation of sale, I deposited 25% of the my lord bid
Yes,
amount.
yes, I remember now.
Well, two things. Well, so far as the law is concerned, my learned friend relied on section rule 9.4 and 9.5 of the surface rules. Now, well, so far as this is concerned, well, there are two things that I have to say in this regard. If your lordship will kindly take up, my lord, the sale notice once, which is a part of my lord, the writ petition at page 17.
Writ petition ta dao. Yes.
Look, your lordship will find, my lord, the sale notice, my lord, is
Page.
serial number 6. My lord, concerns, my lord, the sale of the present property.
I can't hear you, Mr. Shah.
Serial number 6, my lord, at page 17.
17.
Yes, my lord, 17. This is the sale notice.
Yes.
Now, my lord, serial number 6 is Jupiter Spun Pipes Casting Limited. This is, my lord, the property in question. At the extreme right-hand column, my lord, your lordship will find, well, it's in extreme fine print. My lord, I have difficulty reading it. But, my lord, this is, my lord, ultimately made subject to the result of, my lord, litigations. My lord, your lordship will have, my lord, a clearer picture of this if your lordship takes up, my lord, page 30 of Can 2, my lord, where, my lord, the second sale notice in identical terms was published. My lord, may I request your lordship to kindly, my lord, have a fleeting glance at, my lord, page 30 of Can 2.
Or 30?
Yes,
No,
my lord,
13.
30.
30.
30.
Yes.
Like here, your lordship will find, my lord, the sale notice in respect of the second sale.
Yes.
Like, because after, my lord, they said that, my lord, they are not going to go ahead with my sale. This is second. Kindly see here. My lord, here your lordship will find, my lord, there's a box, my lord, name of borrower, etc. Then, my lord, in the box, your lordship will find, my lord, there's a, my lord, horizontal, my lord, table within the table. It says, the sale shall be subject to the outcome of SA 359 of 2017, SA 174 of 2019.
Where are you seeing all this?
Well, this is, my lord, just, my lord, under the portion which
Yes,
says
yes,
physical
yes.
possession.
Yes, yes.
The sale shall be subject to the outcome of SA 359 of 2017, SA 174 of 2019, MA 30 of 2019, and SA 332 of 2015, all pending before the DRT 3 Kolkata, regular appeal 20 of 2018 in SA 332 of 2015, pending before the DRT, and, my lord, the CS number 390, my lord, which is the, my lord, suit in which, my lord, the order came to be passed of 2014, FMA 1074 of 2019 with can such and such pending for the High Court at Calcutta and other connected cases. Now, my lord, so far as this is
What is the
concerned,
date of this? Page 30?
my lord, this is, my lord, the second sale notice. My lord, this was published, my lord, on 4th March 2023. Your lordship will find that at the bottom of the page. But, my lord, we are not really concerned with the second sale notice.
Yes.
We are concerned with the first sale notice, which was published on 28th October 2022. I just, my lord, refer to that because, my lord, that is in more legible, my lord, print.
That is which page of?
Well, that is page 17 of the writ petition.
Yes.
Now, my lord, when, my lord, this sale is made subject to, my lord, the result of litigation, naturally, my lord, if there is an interdiction, my lord, on the sale by pursuant to orders of court, well, you cannot, my lord, proceed to say.
Mr. Shah, can you call that an interdiction? What can you say it
Well,
is?
Justice, my lord, Rao has, my lord, in his lordship's order, my lord, said that the sale notice cannot go through, sale cannot go through. And, my lord, there is a, my lord, suspicion raised with regard to, my lord, the, my lord, enforcement of the mortgage itself. And before that, my lord, the Debt Recovery Tribunal also, my lord, passed an order saying that very well you may go through with the sale, but the seller will not have the, my lord, title to the property in the sense that he cannot deal with it.
So Justice Rao said that the mortgage cannot go through.
No, my lord,
what is it?
Justice Rao, my lord, looked at the mortgage, found that, my lord, there were suspicious circumstances,
Yes.
my lord, with regard to creation of the mortgage, and hence, my lord, passed an order of injunction, saying
Yes.
that the mortgage property cannot proceed to sell.
And the mortgage property is what you bought.
Yes. That's number one. Number two, my lord, in any case, in any event, my lord, notwithstanding this particular clause, my lord, your lordships have held, my lord, in a number of judgments, that, my lord, ultimately, my lord, Rule 9 sub Rule 4 and Rule 9 sub Rule 5, my lord, they really come into play. My lord, when, my lord, I have not made the deposit without any fetter, without any restriction, my lord, despite having, my lord, undertaken an obligation to do so. Now, my lord, my obligation is always, my lord, made subject
So
to.
it is default simpliciter.
Yes, that's right. Now, my lord, so far as this is concerned, my lord, I would just like to, my lord, hand up to your lordship, my lord, judgments, my lord, 4 judgments. My lord, of course, my lord, the first one is, my lord, something that is perhaps a little, my lord, too pithy, but my lord, nonetheless, if your lordship sees, my lord, 2021 SCC online SC 3340, I'll be very brief. Well, at paragraph 3, it's a one-page judgment. Paragraph 3, having gone through the impugned judgment and orders passed by the High Court, we are of the opinion that the High Court ought to have allowed the refund of the amount deposited being 25% of the auction sale consideration, considering the fact that though initially the appellant deposited 25% of the auction sale consideration, however, subsequently she could not deposit the balance 75% due to COVID pandemic. It is required to be noted that subsequently the fresh auction has taken place and the property has been sold. It is not the case of the respondents that in subsequent sale, lesser amount is received. Thus, as such, there is no loss caused to the respondents. Considering the aforesaid facts and circumstances, we allow these appeals and set aside the order of forfeiture of 25% of the amount of auction sale consideration and direct the respondent bank to refund the entire earlier deposited by the appellant.
What will be the loss caused here, Mr. Shah?
Well, there is no loss because ultimately they could not proceed to sell because the court has injuncted them. There is no loss at all. Number one. Number two, my lord, here, my lord, if your lordship remembers, my lord, in Kailashnath Associates, now the law is that, my lord, there's a pre-contract.
Pre-estimate.
Yes, that's right. Not only pre-estimate, it says, my lord, when it comes to forfeiture, if you have not entered into a contract, let's say you say that I will, my lord, pursue my bid and you deposit a bid amount and then you do not pursue the bid, then, my lord, forfeiture is justified.
Yes.
But when it matures into a contract, my lord, then, my lord, you cannot simply go ahead and say I'll forfeit. Now, my lord, here, as soon as you accept my bid, my lord, there's a contract. I pay 25% in pursuit of the contract. You are not in a position to perform your obligation in the contract. So, my lord, the question of my lord coming forward and depositing the rest of the money does not arise. Well, that would also sound in the doctrine of reciprocal obligation. If you are not in a position to perform your reciprocal promise, my lord, you cannot call upon me to perform my promise. My lord, second judgment, my lord, in this regard, my lord, the judgments of our, my lord, High Court, my lord, if your lordship kindly sees, my lord, this is, my lord, a judgment reported in 2023 SCC Online, Calcutta, page 33. May I request your lordship to kindly come to paragraph 3.
Yes.
The bank's case is that on 28th October 2011, the respondent number 2 issued a notice under 13.2 of the SARFAESI Act calling upon Brilliant to repay the dues of rupees such and such, and thereafter the bank issued possession notice on 25th May 2012. Auction sale notice was issued on such and such. Ishpat participated in the auction, was declared to be the successful bidder. Ishpat paid 25% of the bid amount, being such and such, on 7 September. Thereafter, by a letter dated such and such, Ishpat was asked to pay the remaining 75% within 15 days, but it failed. And as such, earnest money was forfeited by notice. In the midst of thereof, Brilliant offered, this is the borrower, offered OTS proposal. Now, I don't want to trouble your lordship with the rest of the facts. Kindly turn to paragraph 9.
Yes. Yes.
Well, what transpires is, on the one hand, they were considering the OTS proposal, and on the other hand, pursuing the sale and asking for payment of the balance 75%. That your lordship will find from paragraph 9.
Yes.
He argues that on the one hand, bank was considering the OTS proposal of Brilliant, and on the other hand, was proceeding with the auction process. Such OTS of Brilliant was ultimately accepted after receipt of 25% amount from the appellant. Not the case that the bank through such OTS had received a lesser amount than the bids offered in the auction by Ishpat. Then, my lord, if your lordship kindly turns the page, paragraph 13. Well, after the issuance of the public notice on 29 July 2017, e-auction was conducted on 6 September 2017. 25% of the bid amount was received by the bank on 7 September 2017, and without any intimation as regards confirmation of sale, the amount was forfeited by the impugned notice or email dated 7th October 2017. In the midst thereof, the bank was considering the OTS proposal as given by Brilliant on 1st August 2017. The said proposal was allegedly cancelled on 6th October 2017, but no such notice has been produced before this court. Now, just pausing for a moment, Well, they have not yet given any notice of forfeiture of the money paid by me, which is more than 4 crores of rupees. Well, then kindly see the last paragraph at page 15. Paragraph 15, I'm sorry. The word forfeiture has not been defined under SARFAESI Act, but it amounts to loss of a legal right by means of some breach of an obligation. If left absolutely unfettered to the discretion of the authority, it may possibly result in an extremely harsh order. The power of resumption and forfeiture needs to be exercised only as a last resort and in a reasonable manner. Such reasonability has to be established on the basis of facts and circumstances of the case. We are not satisfied with the manner in which the bank has ultimately forfeited the earnest money paid by the appellant. Appellant's apprehension that there was a dispute as regards possession of the properties put up for sale could not have been ruled out, since admittedly for non-payment of dues of the bank made an attempt to sell the mortgage properties of the borrower brilliant in the such and such junction. And then, my lord, paragraph 18, my lord, the forfeiture, my lord, was set aside. My lord, then, my lord, another judgment of my lord, our High Court. My lord, this was, my lord, in fact, delivered by your lordship. Well, this is in the case of Subharaksha Kali Rice Mills. Well, at paragraph 3 again. Well, at counsel appearing for the petitioner seeks interference of this court on the ground that the auction conducted by the bank is without jurisdiction, inasmuch as the respondent bank was party to an order dated 15 December 2016 passed by the DRT under a section 17 application filed by the borrower, which was essentially in the nature of redemptions. They were seeking to redeem, and while the redemption process was on, property was being sold. Well, if your lordship will kindly turn to page 4, just above paragraph 6. Well, about the last six lines of the previous paragraph. The DRT by an order dated such and such stayed the order of DRT and restrained the bank from confirming the sale. Well, that is what happened. Then next page. Well, at about 10 lines from the bottom of the page. 5th, the bank accepted further payments from the petitioners towards 100% of the bid amount, even on 23rd December 2016, without divulging the order passed by DRT on the same date, restraining the bank from confirming the sale. My lord, here, of course, we have come to know. And then, my lord, paragraph 9. Further, by the final order of the DRT dated such and such, the matter was relegated to the DRT for being considered afresh. Hence, the question of redemption of the borrower, that is the prayer for settlement of the dues, remained an issue before the DRT for fresh consideration. If this was the case, the bank could not have proceeded further against the petitioners in terms of forfeiting the deposits or for invoking any penalty against the petitioners. I need not, my lord, trouble your lordship with the rest of it. And, my lord, then a very recent judgment, my lord, of the Honorable Supreme Court. This is reported in 2023 SCC Online.
Mr. Shah, you forgotten that I had dictated about 3/4 of the order. Now you want to cite judgments and orders.
That, my lord, I remember.
Unless you are preventing the court from passing an order.
So that's it. Well, that
Yes.
Mr. Devnath Ghosh was not the culprit. I remember that.
Yes.
Well, here, my lord, identical situation. Well, if your lordship sees paragraph 4, well, 2023 SCC Online SC 392. My lord, the facts are, my lord, more or less similar. My lord, 25% deposited. Then, my lord, there were a lot of disputes. But I shall, my lord, straight away take your lordship to the paragraph which is, my lord, relevant. Kindly come to paragraph 22.
Yes.
We have already noticed the narration of facts, but it will be apposite to summarize for better appreciation. The auction notice in the first instance was published on 18 June 2013 with the reserve price of 1.19 crores, and the appellant's bid of 2.01 crores was the highest. Earnest money of 11.19 lakhs was deposited on 22nd July 2013, and the bid was finalized on 26 July 2013, and 25% of the bid in terms of the auction notice of 38.35 lakhs was deposited by the appellant on 27 July 2013. This fact has not been disputed, that DRT passed an interim order on 26 July 2013, and the fact that the proceedings had been initiated and pending on the date when the auction was held and the date on which 25% of the bid amount was deposited by the appellant, that is 27 July 2013, was never brought to the notice of the appellant, which would have given him an option to revisit as to whether he may proceed with the auction or withdraw at that stage. This fact can further be corroborated, which has come on record that even when the correspondence was made by the first respondent, only request made by the appellant throughout was that he
Wait,
had no
Mr. Shah, tell me what the decision was.
I'm sorry, my lord.
What was the decision? Don't place that
Well,
entire paragraph.
ultimately, my lord, the forfeiture was set aside, my lord, and the money was directed to be responded. That's
Which
my lord,
paragraph is that?
26.
26.
Now, my lord,
Yes.
well, let me just place this one paragraph. So far as submission made by the first respondent in reference to Rule 9.
Mr. Shah, I've read 26.
Yes. Now, my lord, what I'm
And it deals with 9.5.
Yes. My lord, my respectful submission is this. Well, I should have, my lord, also handed up Kailashnath Associates, but my lord, that clearly says that, my lord, so far as the law of forfeiture is concerned, it is, my lord, in, my lord, two parts. My lord, if you today say that I shall make a bid and, my lord, deposit a bid amount and then, my lord, withdraw from the bid, then that money can be forfeited because, my lord, that is within the domain of, my lord, public, my lord, promise. But, my lord, if today it matures into a contract, as it does, my lord, with the acceptance of an offer, in that case, my lord, you cannot simply forfeit, even if there's a provision for forfeiture. Now, my lord, the provision for forfeiture here is Rule 9, my lord, 5 of, my lord, a statutory rule. That is the distinction. But, my lord, so far as the statutory rule is concerned, my lord, it is really to prevent a loss. In this case, my lord, the sale itself was subject to, my lord, the result of litigation. Then, my lord, there's an injunction. My lord, these are my respectful submissions.
Thank you. Mr. Chaudhary, you have to come back on some other day. All right. Tell me when.
My lord, 11th or 10th, my lord.
You're enjoying an order?
No, my
No, my lord.
No.
Well, my lord, the sale, my lord, they had tried to, my lord, they cancelled my sale. They did not forfeit my money per se. My lord, they have, my lord, ultimately be prevented from going ahead with the second sale notice because of the order of injunction. But, my lord, they are not returning my money to me. I now say, my lord, refund my money to me.
So they are injuncted from proceeding with the sale, but they haven't returned the money.
No.
My
My
lord, that
money has
is,
not been-
my lord, that is after the, my lord, the contract is completed. My learned friend cannot take.
Very well, Mr. Chaudhary, you come back. I will hear you.
Very.
Yes. Learned counsel for the petitioner has made his submissions. Stop. List this matter on 8th May 2023 as prayed for.
Well, could it be 10th, my lord?
Yes, my lord.
If it's not difficult.
এগুলো কবে থাকে? Either 8th or 15th, Mr. Shah.
Then, my lord, kindly have it on the 15th. My lord, I'll be in some difficulty on the 8th and 9th.
15th
Very
as
great.
prayed for. 15th May as prayed for. Original side.
Deeply.
Original side, item number 1, Suresh Kumar Patni.
Application, my lord. Lord, the challenge by the writ petitioner of your lordship is the issuance of show cause notice under the willful defaulters guidelines, my lord, on the ground that the under section 96 of the Insolvency and Bankruptcy Code, moratorium has been declared against the same individuals, my lord, before the learned company law, the NCLT. Now, my lord, that is the sum and substance of my challenge, that in view of section 96 of the moratorium being declared,
IBC.
IBC.
Must be here.
Maybe. Surface na insolvency.
IBC.
IBC, surface.
We have a copy.
মোটা বইটা দেখুন, মোটা বই আছে। Lord, kindly takes chapter 3. Lord, first takes, my Lord, under chapter 3, it deals with insolvency resolution processes.
Yes.
Lord, section 95. I'm sorry. Section 95, kindly
Yes.
takes, my Lord. It says application by creditor to initiate insolvency resolution process.
Yes.
A creditor may apply either by himself or jointly with other creditors or through a resolution professional to the adjudicating authority for initiating an insolvency resolution process under this section by submitting an application. And my Lord, several other, my Lord, criteria have been laid down. My Lord, kindly come to section 96. My Lord will only keep in mind, my Lord,
Yes.
that this chapter 3 deals with insolvency processes of individuals or firms.
Yes.
Lord, kindly now come to section 96, my Lord.
Yes.
It says, my Lord,
Yes.
Lord, when an application is filed under section 94 or section 95, A, an interim moratorium shall commence on the date of the application in relation to all debts, and shall cease to have effect on the date of admission of such application. And during the interim moratorium period, any legal action or proceedings pending in respect of any debt shall be deemed to have been stayed. And, my Lord, Roman 2, the creditor of the debtor shall not initiate any legal action or proceedings in respect of any debt.
So the difference between 14 and 96 is this is interim.
No, 14 is also, my Lord, interim.
No, 14 of that is
My Lord,
also
14
with
provides for, my Lord, a moratorium on the corporate debtor itself. Here, my Lord, the moratorium is not on the individual concern. The moratorium is on the debt.
That is more wide in my respectful submission. The debt itself, nothing with relation to the debt can be, my Lord, initiated under 96 1B Roman 2. The creditor of the debtor shall not initiate any legal action or proceeding in respect of any debt. Now, my Lord, kindly considers what is the purpose of declaring an interim moratorium under section 9, which is almost akin with, as my learned friend rightly points out, with that minor difference, my Lord, 96 and 14. What is the purpose behind it? Lord, kindly comes to, my Lord, section, my Lord, 105. The whole purpose is to, my Lord, appoint a resolution professional who is to assess whether to admit or reject the application by the creditor. And, my Lord, 105. The debtor, my Lord, if I may read, the debtor shall prepare in consultation with the resolution professional a repayment plan containing a proposal to the creditors for restructuring of his debts or affairs. 2. The repayment plan may authorize or require the resolution professional to carry on the debtor's business, trade, or on his behalf, realize the assets of the debtor, or administer or dispose of any funds of the debtor. Then 3. The repayment plan shall include the following, namely, justification for preparation of such repayment plan and reasons on the basis of which creditor may agree upon the plan, provisions for payment of fee to the resolution professional, such other matters as may be specified. So, my Lord, this whole intention of 96 is to allow the professional, the resolution professional, to form a resolution plan in consultation with the individual against whom the application is made. Almost akin to, my Lord, the provisions which are applicable to the corporate debtor in respect of part 2. Now, my Lord, in this respect, if I may now, my Lord, come back to the facts of this case. A similar order under section 96 has been passed against these very same persons.
On your application?
No, my Lord, on the application of one of the creditors, State Bank of India. Now, my Lord, I have to form a resolution plan and give it to the resolution professional. Now, my Lord, in the interagnum, if my learned friend, being one of the other creditors, a bank, my Lord, initiates a willful defaulter proceedings, my Lord, naturally my credit score will be affected. My entire, my Lord, reputation in the market will go. My Lord knows the ultimate will be advertised. Now, my Lord, if that is there, my whole credit worthiness will go down. My Lord, I will not be able to, in all probability, be able to float a resolution plan under section 105. And the whole purpose of the objective of section 96 and 105 and part 3 of the insolvency and bankruptcy code will go, in my respectful submission. Now, if that is so, section 96 is incorporated for a purpose to be achieved. Clearly says will not initiate, no creditor will initiate any further legal proceedings, and not only in respect of the corporate debtor as under 14, but in respect of the debt. So here is another creditor, despite that order under section 96, same bank, my lord, now my lord, taking this refuge of willful defaulter and proceeding.
Same man as in?
No, same
Same
bank. Now, my lord, if this is the situation, my lord, I am saying that I am entitled. I am saying that the very, my lord, the initiation of the issuance of notice under willful defaulter guidelines is bad. It does not
For
have the
that it
jurisdiction.
is, you're relying on 96.
96, my lord. Read with, my lord, 105. Because then the ultimate purpose of 96
Yes.
will be defeated.
Yes.
Now, my lord, one more aspect, my lord. During the insolvency proceedings against a corporate debtor,
Yes.
which now, my lord, stands, my lord, concluded, my lord, an application under section 66 of the Insolvency and Bankruptcy Code was moved against the corporate debtor. Not just, my lord, for a second, my lord, may I place section 66? My lord, it was regard to fraudulent trading or wrongful trading. That was the allegation. My lord, the order has been passed by the honorable
Who is the petitioner before the court?
My lord, the petitioner before the court was, my lord, this writ petition, my lord, the guarantors of the company who are, my lord, now, my lord, now they are being proceeded against before the NCLT under part 3. And section 96 orders have been passed against them in proceedings against them. The very same person.
On the application made by the bank?
By the bank.
No, different bank.
Different bank. State bank.
Yes.
Now, my lord, kindly, my lord, that section 66, my lord, order that was passed in the proceedings initiated against the corporate debtor, if your lordship kindly takes that order, which starts at page, my lord, 15, and kindly come to straight away page 35 and 36, my lord. Kindly, my lord, takes the order, it starts at page 15, my lord. Maybe confused. Section page 15, my lord. Kindly takes the heading at page 15, my lord, an application under section 25(2)(j) and section 66 of the Insolvency and Bankruptcy Code, read with regulation 35(a)(3).
Page 36.
Yes, my lord. Kindly takes, my lord, 35.
35.
First, my lord, 35, paragraph 48.
Yes.
And then we note, my lord, I quote a portion of the order, my lord. We note that 2 independent auditors appointed by the financial creditors prior to initiation of CIRP, when the trust and retention account was operational, have cleared the transaction in question without any demur. Further, it is not the resolution professional's case that any benefit in the form of any additional facilities from the financial creditor has been obtained by the corporate debtor or its key managerial personnel. Therefore, the allegation that the transactions were intended to defraud the creditors does not hold water. I'm sorry, my lord. Consequently, the allegation under section 66 cannot be sustained. Lord, kindly come to the next page, my lord, page 36, paragraph 50. We cannot, however, help but observe that the allegations made by the applicant seem to be made due to lack of information on the said matters, which may be a result of non-cooperation from the respondent and application in which regard has been filed. We, however, deprecate the conduct of the respondent in not submitting proper explanation when opportunities in this regard were given by the transaction forensic auditor to explain the transaction. Lord, that's all. My lord, so paragraph 48, my lord, clearly says that, my lord, we have been, these same people, my lord, have been dishonored, have been completely discharged of any allegation of defrauding the creditors, or, my lord, which is almost akin to, my lord, siphoning away the funds or being a willful defaulter. That is also, my lord, completely repelled. Now, in these circumstances,
repelled when?
My lord, this has been passed in, my lord,
8/10/21.
8 October 2021, page 15, your lordship. Now, thereafter,
no, repelled. You have challenged something else before in the writ petition.
Yes, my lord, I have challenged thereafter.
79.
My lord, I have challenged the show cause notice, my lord, which is at, my lord, page 37.
Yes.
Which is, my lord, dated 4th of December 2021. The order under section 96 at page 49, my lord, is dated 12th of September 2021. So after 12th of September 2021, after the interim moratorium is declared under section 96, they have issued the first show cause notice dated 4th December 2021. So I am saying in view of the earlier order of section 66, which my lord exonerates me from any kind of allegation of defrauding the creditors. Second, my lord, already interim moratorium has been declared under section 96. You cannot proceed against me or the debt due against me in any kind of legal proceedings against me, my lord.
And what
which
are they
also cover-
threatening in these 3 letters? Page
My lord, they are
36.
saying, my lord, page 36, my lord, they'll obviously, my lord, if they, my lord, kindly come to page 36, my lord, they are saying, my lord.
No, which letter
37.
contains the threat? 79.
My lord, 79, my lord, we have been writing, the several show cause notices have been given. We have been responding to the show cause notices.
Very well. Yes, Mr. Chatterjee. How much time will you take?
I'll take 15 minutes, not more than that.
Then come back this week or next week?
Whichever date is convenient to my lord, well, next week would be preferred. My lord. Tomorrow I'll have some difficulty.
Very well. Yes, learned counsel appearing for the respondent bank will make his submissions on when? Give me a date. 8th, 10th.
10th, my lord.
On 10th May 2023 as prayed for.
I'm
List this
grateful, my
matter on that date.
My lord, only, my lord, humble submission, my lord. Since we are before your lordship, I hope, my lord, Mr. Chatterjee is also here. In the meantime, they will not take any decisions before the review committee or any other decision which will prejudice the writ
They have not taken for this long. I do not think they will be
just
taken.
that- just
Anyway,
that-
individual, I'll advise them not to.
Just that, my lord, understand.
I'll advise
Since we
them
are
not.
before your lordship, my lord.
Yes, call on the next matter.
I'm grateful, my lord.
Item number 2, Preeti Trading Company.
Yes. The first writ petition,
I can't hear you.
the
Microphone.
first writ petition, your lordship, we are seeking an extension benefit under a scheme called Government Guaranteed Credit Facility Scheme, which your lordship was available to the borrowers under MSME. Now that's
And that scheme is still continuing.
no, when we filed the writ petition, it was in force. Now it has expired on 31st of March 2023.
Then what relief can the court give you?
We have made representations to that effect. There is no scope for interim order. If they want to file an affidavit, they
No,
can
why
come.
affidavit?
No.
If the scheme is no longer in existence, what relief can I give you?
At the time when we filed the writ petition, it was in force. But during the pendency, it has.
Who is the answering? You're the answering respondent.
I am the Punjab National Bank. Punjab National Bank. Respondent
Yes.
number 1.
What do you have to say?
Well, there was a writ petition earlier also that has been rejected. Kindly see page 155.
155.
Yes. On the sales of ground. On the same ground.
No, this was not on the same ground. This is with regard to the increase of a credit limit. Lordship, apart from prayer A, we have other reliefs as well, which has not become infructuous. Prayer A, we are seeking
1
for
minute,
disbursement.
please.
Yes, sorry.
Why are you saying same ground, totally on different grounds?
Kindly see
What is same ground?
They were asking for the enhancement of the credit limit by way of making a representation to the bank. So they went to filing a writ petition. The Honorable Court has said that it cannot be the bank discussing what to do, what not to do. Now, kindly see page 159. Kindly see 159. There is a London City Civil Court proceeding pending before the London City Civil Court. There is the order of London City.
No, what was the reason given by the coordinate bench for dismissing the writ petition, according to you? What was the reason given?
The reason given, kindly see page 157, my lord. The reason is that the loan agreement says something else and they are asking for something else. This is what.
Sorry, I can't follow.
The reason given by the Honorable Coordinate Bench is that there is no scope of the writ code directly declaring a loan agreement void. Meaning they were asking in that writ code that for restructuring of the loan account on a particular rate of interest, which the Honorable Coordinate Bench has been declined. Now kindly see page 159, my lord. There are
Yes.
proceedings before the learned city civil court.
Asking for what is a prayer?
Prayer, my lord, asking for ad interim injunction. Can you see para B, page 161.
So this you have asked for in the city civil court.
Yes, your lordship, this we have asked for. But the fact is that here I am also challenging, there are other reliefs with regard to declaration of account as NPA. That is also I'm challenging in this writ petition. And non-disbursement of the credit facilities. If your lordship takes my prayer, because these are the subsequent reliefs, your lordship, page 27, if your lordship takes. First relief is with regard to the disbursement of the scheme. Second, if your lordship sees, is with regard to a mandamus with regard to the releasing of the drawing power, because my drawing power was higher, which was illegally reduced. That is one of the subject matter of challenge in the writ petition.
No, but this coordinate bench said that there is no evidence that you took this loan or not.
Yes, your lordship, this loan is not with regard to this. This is a separate loan transaction, which I am challenged by a writ of mandamus to be declared as null and void. That is on a separate cause of action.
Yes, again, you've asked for the same prayer. This to declare the sanction as void ab initio, which the coordinate bench said that the court can't do.
Your lordship, these prayers I am not pressing for.
Then
I am pressing for prayer B, prayer C, and prayer E,
Prayer B.
as well as prayer G. Some of the properties which the bank is illegally holding on to with regard to the credit facilities available. So some of the reliefs are still pending. It has not become infructuous. There is no scope for interim relief, I admit that, in the writ petition.
no, in any case, I will.
My lord, I am for the
see
option
with no-
purchaser, my lord.
Yes, yes.
My lord, this pair G is obviously against me, my lord. It will affect me, my lord.
There
My
are-
lord, they have challenged they purportedly they have challenged the NPA 13.2, 13.4 and the auction notice. And all these are also before the learned DRT. They have filed an essay before the learned
13 to
DRT.
13 I am not challenging. That is not my prayer in the
In DRT, obviously 13 NPA, that is the
DRT,
NPA Act, Surface Act. NPA 13.2, 13.4 and the auction notice. All these are before learned DRT. They have challenged it. And that is
So
pending.
prayer G is for why the registration of properties should not be quashed.
Yes,
What registration of properties? In favor of you?
my lord.
You're the auction purchaser?
I'm the auction purchaser.
Lordship, NPA
And that same
declaration
sale notice and the auction process is under challenge before the learned DRT.
The petitioners have gone for the
Yes,
DRT?
yes, my lord, the petitioners have
Your Lordship, the NPA declaration I am saying is in violation of the RBI guidelines. That I can always come up in writ. That is not the subject matter of challenge the DRT. DRT is 13.2 and 13.4, which I have not challenged in this writ petition. NPA declaration is in violation of the RBI guidelines. That is what my prayer is.
That is which prayer?
Your Lordship, your Lordship takes this prayer E, F. These are all subsequent reliefs, your Lordship, pursuant to which this sale has taken place. I am saying that the NPA declaration is bad. So any sale
Very well, I'm
effected on the-
recording that all the reliefs which are pending before the DRT or the city civil court will not be agitated by you here in this court.
Your Lordship will not make that.
No. I have
observation.
to, otherwise
Because
I'm going to dismiss the writ petition.
Some of the prayers are.
No, I'm making that, otherwise I'm
before
going
the
to
DRT.
dismiss the writ petition. Yes, the petitioner seeks direction on the respondent bank to disburse the benefit under ECLGS scheme stop. The scheme was admittedly till 31st March 2023. Stop. The petitioner says that the scheme was in existence at the time of filing of the writ petition, i.e. on 29th March 2023. Stop. The other reliefs relate to proceedings which are pending before the Debts Recovery Tribunal, For instance, prayer G, where the petitioners have asked for, where the petitioners have called upon the respondents to explain registration of properties in favor of the private respondent / auction purchaser, and asked for the and prayed for the registration to be quashed. Stop. There is the petitioner has also filed a suit in the before the Learned City Civil Court where the petitioners have sought for a similar direction on the respondent bank in terms of sanction of the loan. Stop. Next, apart from there being no scope for any interim order, comma, it is made clear that the reliefs canvassed by the petitioner before the DRT and the City Civil Court shall not be considered by this court at the time of hearing of the matter post affidavits. Stop. Next, the petitioners shall be at liberty of proceeding with the pending matters before the concerned fora. Stop. Next, affidavit in opposition within. By 19th May 2023, reply within 2 weeks after reopening. Stop. List this matter on 20th June 2023. Next.
Item number 3. Timothy Fashions Private Limited.
Issue 3 is my writ petition where we are challenging an illegal encashment of a fixed deposit, even though it was not pledged with the bank due to failure of certain credit facility.
No, this is also an NPA notice.
Yes, Your Lordship, NPA notice we have challenged because in this matter, Your Lordship, this is in violation of the RBI guidelines. That is why. Your Lordship, RBI guidelines are mandatory upon a bank to follow. If
That's of 29th April 2022.
Yes, 2022. There's no urgency, Your Lordship, in this matter. This is a change brief which has come to me.
There is an admitted delay in filing of the writ petition. Stop. The petitioner has challenged an action of the bank declaring the petitioner's account as NPA by way of a notice dated 29, which was communicated to the petitioner by a notice dated 29/4/2022. Stop. The writ petition was filed.
Twenty-ninth of March 2023.
A year later, on 29th March 2023. Stop. Next, you are appearing for?
For the respondent number 1. Respondent number 1, Indian Bank.
So I also
There
challenge
is-
the FD that has been illegally encashed from my account.
Yes, there is no scope for any interim order. Affidavit in opposition, Aki direction. Aage term. Next.
Gratefully.
Item number 4.
I
Follow
take
with
my
the
booklet, I appear
Canada
for the
Bank.
petitioner.
I'm for the respondent bank.
In this matter, what has happened, my lord, the predecessor in interest of the petitioner was the my lord, owner of a land along with building. The respondent bank is enjoying a portion of that property for their purpose. Thereafter, my lord, the predecessor in interest, my predecessor in interest died on September 2022. Thereafter, my lord, as per the Hindu Succession Act, the granddaughter, my lord, granddaughter of the predecessor in interest, that is the petitioner, is only the sole legal heir. I approached the bank.
Who are you?
Lord, I am the granddaughter.
Yes.
And as per the Hindu Succession Act, my lord, I am the only legal heir, my lord, who is entitled to inherit the properties.
Yes.
Now, I approached the bank in October by a letter, my lord, saying that according to Hindu Succession Act, I am the only legal heir. Kindly pay the rent to me, as well as the property, as well as to execute a fresh lease deed. Not done. Thereafter, I submit a affidavit affirmed before the learned Metropolitan Magistrate, declaring my as myself as the sole legal heir. No, they say that along with her mother, my mother should also be the legal heir, and it has to be
Your
executed
mother
by
is
both.
alive.
Yes, alive.
Then naturally.
No, my lord, may I place that, my lord?
No, you come back on some other day, please.
Very well.
Obviously, your mother has to be the legal heir.
No, my lord, as per the first category 1, my lord, it is only the granddaughter of the
My
predecessor.
submission is they have to give me some heirship certificate. Heirship certificate is necessary.
Yes, give
it to us and we shall do the needful.
The act is, my lord, crystal
No, no,
clear.
I will not come to any finding. Give the heirship certificate
That's
and
all-
get
that's
what you
all
want.
we require.
No,
and that
no
will be
finding.
No, look, may I? Look, the Calcutta, they are requiring a heirship certificate from the Kolkata Municipal Corporation.
Yes.
So in my humble submission, my lord, my instruction is, my lord, the Calcutta Municipal Corporation is not competent to give that legal
District
heirship
Civil Court
certificate.
can give. There are
Get
so
it from
many other
anywhere.
It is a
competent
immovable property,
authorities.
my lord. Had it been a movable property, my
Get
lord,
it.
I could have
Otherwise,
gone.
I'm not going to, I'm telling you, I'm not going to come to any finding. Just get it from any competent authority and give it to them.
That's all, my lord.
I have
We
already
don't
given
require
an
anything
affidavit.
else.
No, no, no.
affirmed
Affidavit
before
will
the-
not do. Just give an heirship certificate. That's all.
That's all.
Look,
Yes, where is the heirship certificate required? Where is your letter?
My lord, there are correspondences on the mail. We
Yes.
have only told them time and again that we are ready to clear the dues. Only give us a document to that, because, my lord, the previous account where we used to remit the rent, my lord, it's in the 3 names. The grandmother, the dead person's name, the mother's name is there, and the granddaughter's name is there.
And the mother is alive.
Mother is very much alive, my lord. So there could
My
be
lord,
a dispute
in that
in the
case, my lord,
future.
may
How
I
would
place
we
one section,
Yes.
only one section
No,
of the
no.
Hindu Succession Act.
I'm
is
telling
not
you, I will direct this. Tomorrow, এটা কালকে রাখো তো, list this matter tomorrow.
My lord, may I then take instruction and come back, my lord?
Well, it's a very small and simple issue. They just give me something, some document, and I'm doing
Tomorrow.
I'm willing
Very
to do the needful.
And I'm making it clear to you so you don't waste time. I will just tell you to furnish the heirship certificate.
Very well.
Grateful, Your Lordship.